You don't even know Jamari Brick, so he's going to come out here and you can look at it and you can see that is not Jamari in your picture. I just talked to him 5 minutes ago. That's not Jamari in either one of those pictures. Okay. You filed a notice of hearing in October. I think the witness isn't here. That's not my fault.
Good morning.
Good morning, Judge.
Good morning. Mr. Niddle, are you ready?
Yes, ma'am.
All right.
I have two cases on the docket today. One is Chase Davis. That's for a bond hearing.
All right, that's number 8 on the docket, case 23 CF 1842. Could I please get appearances?
Yes, Your Honor. Taylor Sharpless for the state.
I was going to say, we could do Pride if you want.
Bring back.
Actually, Judge, I'm going to call Jamarian Pride up. They brought him.
All right.
I think Ms. Sharpless is the...
That would be number 9 on the docket, 23 CF 322. Could I please get appearances on Mr. Pride's case?
Judge, we're here on a motion to dismiss. I know the state has filed a traverse. They believe that one of their investigators looked on Facebook. He found a picture. Let me first say that there was a raid at this house. There was drugs found in the house. Apparently there was like 6 separate bags of fentanyl found throughout this house. One of the bags was found in a white jacket. The state believes that there's a picture of a person wearing this white puffy jacket, and they believe that picture is of Jamarian Pride. However, that picture is not of Jamarian Pride. I have the picture here. Is that to be presented to the judge?
Thank you.
Gentleman in the white jacket, they believe it. The officer believed that was Jamarian Pride. I think you can look at Jamarian Pride and see that picture is not a picture of this young man here.
So the record will reflect I've been handed a color photo. It has at least 5 people depicted in the photo. I'm going to hand it to the clerk.
There's also a screenshot picture that they believe is, and this picture does look like that picture, but this picture does not look like Mr. Pride. Mr. Pride's much lighter complexion than the people pictured in these pictures. But anyhow, that's the state filed a traverse based on that picture, and I don't believe that picture is valid evidence of Mr. Pride being involved in this case or this matter, because that picture is not a picture of Jamarian Pride. And there is no other evidence that Mr. Pride knew. All the drugs, none of the drugs were located. There were, I believe, 4 individuals arrested. None of the individuals arrested had drugs on them. They found drugs in the apartment where they saw the defendants went in the apartment, a few minutes, came back out, and then when they came back out, they were detained. They went and got a search warrant. They searched the apartment. They did find drugs, but Mr. Pride does not live in that apartment. They did not find any drugs on him, and there's no evidence that he knew or was aware of any of the drugs that were in the house. And that's one of the jury instruction. They had to prove that he was in proximity and that he had knowledge. And they don't have either one of that. They don't have any evidence of that.
So the state did file not only a motion to strike, but also a traverse.
Judge, in response to the motion to strike, we can place Mr. Pride under oath, and I can read the problem was there's no notary at the jail. And I could not get a C4 motion notarized because there is no notary. So I filed it under 3190B, which is a separate motion to dismiss. But I could put Mr. Pride under oath and have him swear to this C4 motion if the court so chooses.
Let me hear from the state.
Yes, Your Honor, so the state did file a traverse and a motion to strike. Your Honor, the state does believe whether or not Mr. Pride or his mother or counsel intends to testify that that's not Mr. Pride in the picture, this is a materially disputed fact. There is, despite what the motion to dismiss says, an officer, at least one officer that needs to be deposed, and that's Sergeant Chisholm. The state does expect Sergeant Chisholm to state that that is Mr. Pride, and if the court looks at that picture of the person in the white puffy jacket, that person does have a gun in their waistband, and also the person in front of him is holding a plastic baggie which looks like drug paraphernalia. He's in the picture with the AK-47, which was found as part of this investigation, Your Honor. So the state does contend that all of these individuals were involved with these drugs and this gun. They knew of the illegal activity going inside the apartment. They didn't just randomly run inside this apartment. They had been in this apartment. And Your Honor, again, just for procedural issues, if there needs to be more of a substantive hearing, usually Judge Ketchel has these kinds of hearings not in the morning, but in the afternoon. So if a more substantive hearing needs to be had, the state would ask for that to happen at a later time, Your Honor.
All right.
I don't have any dispute with what she's saying about the people in the pictures being involved in the drugs. The problem is the people in the pictures are not Jamarian Pride. That's the problem. The state's saying that picture, which is not in Mr. Pride, is the basis for their traverse.
Well, I believe that there was also the other officer that hasn't been deposed. That's what I...
He has not been deposed. I think it's in the process of being scheduled, if it's not already scheduled. If the court would prefer to continue this and maybe set it again in front of Judge Ketchel, that's fine. The officer, this hearing was noticed in October the 20th. We filed a notice of hearing. The officer's not here, and I don't know why, but he's not, and he could have been. And I would ask if this court is contemplating continuing this or setting it out, that will you consider giving Mr. Pride a signature bond? He's been in jail since February. He's just turned 18 years old. He's never been arrested. It's a travesty that Mr. Pride is in jail.
So I am denying the motion to dismiss. First of all, it's not sworn, but even if it was sworn, the state filed a traverse.
So I would ask that it not be with prejudice, because I would...
Without prejudice.
Okay. Is there any possibility? I don't have a note. I need to have Mr. Pride sign this document under oath. Can the court place him under oath and let him swear to this document?
I'm sorry, you're going to have to locate a notary some other way. We do have a crowded docket this morning.
All right. Thank you, Judge.
Thank you. Was there a motion for bond?
I filed a motion for bond after she filed a traverse because I thought the traverse had merit, but
I did not even, I looked at the docket last night, I didn't see.
well, to be honest, I don't believe Ms. Sharpless had, the motion for bond was filed within the last day or two.
Well, then that needs to be reset on
I
Judge
understand.
Ketchel's next, miscellaneous day. What's that?
It's going to be on December 19th, more than likely. December 14th is...
I'll refile both motions, and you say December 19th is the date?
Yeah, so we can go ahead and set the bond motion on that date if you wish.
December 19th.
All right, thank you.
As far as the pictures, this is Exhibit A and Exhibit B. I have it for ID only, which I keep. I just need to know if it's been admitted.
Do you wish to have that admitted, or, I mean, there wasn't any evidence other than just,
No, I can reproduce that. I mean, it does,
okay. So it's just marked right. Hold on, thank you. All right, and Mr. Niddle, what other case did you have on the docket?
Chase Davis.
Chase Davis, ma'am.
Let me get you here. Please.
The Mary Tom case is set for December 13th for trial.
Okay.
All right, case 23 CF 1842, Chase Davis. Could I get appearances, please?
Yes, Your Honor, Taylor Sharpless for the state.
And
Judge-
Mr. Niddle?
Judge, Mr. Davis is before the court. He was arrested on August 14th. There apparently was a armed robbery at a vape store. And according to Mr. Davis, Mr. Davis basically cooperated with the police, advised them that two of his former teammates at Crestview High School had asked him for a ride, and he agreed to give them a ride, but he didn't know that they were going there to commit a robbery. That's how he's here, but as far as his bond, he was arrested on August 14th. He's been in jail since. He's currently only 18 years old. He resides in Crestview with his foster parents. He's never been in trouble before. He was attending a technical college at the time of his arrest. As I said, the co-defendants were teammates on Crestview High School and asked him for a ride. He wasn't aware of any plan to commit a robbery. He's been determined to be indigent. He cannot afford a high bond. We're requesting his bond status be set to a signature bond with pretrial release, or in the alternative, a $10,000 bond in this case.
State?
Yes, Your Honor, the state does oppose the reduction to a signature bond or to a low cash or professional bond, such as $10,000. The reason that Mr. Davis has been charged in this offense is he's been charged as a principal. As far as the allegations that we're aware of so far, again, this is early in the case and depositions have not occurred, but from the report, Mr. Davis knew that these two juvenile individuals did not have a job. They got back in the car with a large amount of product from this vape store, tobacco shop, and he knew that they did not have the funds to have that much product with them. It's quite a large amount of product. They then went back to Mr. Davis's house, and that's where the product was when the police came to Mr. Davis's house to question him. So the product in question was actually found at Mr. Davis's home. So that's why he's been charged as a principal. Again, the state and the victim who I spoke to but could not be here today because, again, he runs his own business, do believe that a reduction to a $10,000 cash or professional bond would be too low, and then also a signature bond would be too low, Your Honor. So we're asking for his bond to remain the same.
Judge, if I can, they did not find any, they found some wrappers and things at Mr. Davis's house from the vape shop. They did not find the product that was stolen there.
So bond is currently set, correct me if I'm wrong, on count 1, 75,000 cash or professional, and on count 2, 25,000 cash or professional, is that correct?
I believe it's $100,000 bond total.
Total, yeah.
Never been arrested in his life, Judge.
State's requesting bond remain the same.
Yes, ma'am.
Excuse me. Travis, do you have some inmates to talk to? Looks like there's quite a few private lawyers out there.
Count one is a very serious charge.
I agree, Judge, and I acknowledge that, but as I said, I don't believe that Mr. Davis had any knowledge that they were going to, that when he dropped them off, he didn't know that they were going to. He told me the first time he became aware something was wrong was when the guy walked out of the store and he saw the gun in his, I believe it was in his belt. And that was when he first became aware that something was going on. And he wasn't sure at that point what had happened.
On count one, I'm not inclined to reduce the bond. That will remain set at $75,000, cash or professional. Regarding count two, that's the grand theft charge. That's a third-degree felony. It's currently set at $25,000 on that count. That is considerably high for the nature of that charge. I will reduce the bond on count two to $5,000, cash or professional. The other terms and conditions that are set forth on the first appearance sheet, which is no contact with the victim, no trespass at Santa Rosa Mall, no contact with co-defendants, and I can't quite make out the handwriting on one of these others, but...
What are the names of your co-defendants?
I only know one. One's Jaden Brooks.
Jaden Brooks.
Yes.
Maybe that's I think that's pretrial services to monitor.
At level B2?
I think so. Okay, so that's what it is. It's pretrial services to monitor at level B2. So those other terms and conditions will remain in effect.
Thank you, Your Honor, that's all I have.
Thank you, Mr. Nittle.
I'm going to set that position.
Mr. Garrett?
Good morning, Your Honor.
Good morning. And
Your Honor.
which case is yours?
Your Honor, I'm here on behalf of Peter Feckety.
Yes, number 3 on the docket. That is 22 CF 2747. All right, looks like the defendant is present. Could I get appearances from the state?
Noah Lasco on behalf of the state, Your Honor.
Thank you. All right, so this is a motion to reinstate bond. It looks like bond was revoked at first appearance on a different charge on September 17th by Judge Oberleeson.
Yes, Your Honor.
Go ahead.
And Mr. Feckety has been in custody since, I think it was September 17th of this year. And Your Honor, regarding the current case, the felony case here, the aggravated battery, we have been trying to schedule a deposition with the alleged victim for many months. We had one scheduled for October 30th. The alleged victim called at around 1 p.m. for the 1:30 p.m. depot to say that he didn't have transportation, couldn't make it. The alleged victim in this case did take a long time to locate in the first place. He has never provided medical records, and my understanding is he has not responded to the state's attempts to contact him since the canceled deposition on October 30th. We are rescheduled for a deposition on December 12th. I know our process server is trying to find him, but he is currently listed as at large with no available address, doesn't seem to be responding to emails, and I believe he was using his wife's phone, but hasn't been responding to that either. And Your Honor, you know, Mr. Feckety is sitting in jail currently without bond. He's been in there for quite some time. This is starting to cause him very, very significant financial hardships. His son, Aaron Feckety, is having to sell off items to pay rent and bills and things of that nature. And regarding the new case that triggered the bond being revoked, it's an alleged simple battery that took place in the Lowe's parking lot in Fort Walton Beach. And I don't want to go too into the facts on that, but I will tell Your Honor that the first thing the alleged victim said to law enforcement when they arrived on scene is, "You're not going to see any injuries." There were no physical injuries to the alleged victim. Mr. Feckety was arrested for that, but while being arrested and while on his way to the jail, begged law enforcement to get the security camera video from the Lowe's parking lot so that they could see what happened. Initially, one officer didn't want to arrest him, thought it was a he said, she said situation. A different deputy decided to go ahead and place Mr. Fecady under arrest. In no way are these two cases related, other than they are both charged as batteries. I have subpoenaed the video from the Lowe's parking lot. That has been quite a process. It has been preserved. It should be sent to me very soon. And I suspect we'll be getting that simple battery resolved at some point in the near future once we get those videos. My concern, Your Honor, is that if Mr. Fecady is denied a bond, then if we get to the deposition date on December 12th, what happens if the victim doesn't show up again? You know, it could be weeks and weeks before we get him back in front of the court for a bond hearing. And all the while, he's basically losing everything that he has. I did ask Mr. Fecady to prepare a written statement to go in his own words into how this is affecting him. He apparently was not allowed to bring that written statement with him. But I would ask that the court give him an opportunity to address his financial concerns, the things that are going on with him, because he can better express it than I can. Mr. Fecady?
Your Honor, my son, my 9-year-old grandson live with me. The situation right now is we're about 3 weeks from not having a home for my family, not having utilities, not having any way to take care of my son and my grandson. The only thing that I just want to get out of here and get myself back to work so that I can keep my family from having to be homeless. I've never experienced that. It scares me. Every day I don't know what's going on with this. I don't know how long this takes, but it's literally crunch time. Right now I have to be able to get out and go to work. My son cleans pools. He makes $500 a week. He can't cover all of the expenses, even just the basic expenses, the food, the utilities. And if I'm not allowed to I promise I pose no threat to anyone whatsoever. My entire focus is just to get out and preserve my family's ability to live.
Thank you, sir.
And Your Honor, based on his financial hardships, we would ask for a reasonable bond that he can make. Mr. Fecady would, of course, be amenable to anything deemed necessary by the court to protect public safety, things of that nature. If Your Honor were to order something like a GPS, we would ask that it be set to $1 a day because of his financial issues. But he would agree to absolutely anything to try to get out and make sure that he's not homeless. And we just ask that Your Honor reinstate the bond.
What's the state's position?
Judge, my position, or the state's position, would be that this defendant, although he says that he's not a threat to anyone, is currently facing 2 independent charges, both battery charges. In the present case, he's accused of running over a homeless man intentionally, and then he picked up a second battery charge in a different instance. Judge, I would present to you that he's not losing everything because the victim did not show up for a depot. I'd say that he's experiencing financial hardship because of his own actions. I would tell the court that the victim here is homeless. He does not have a place to live. He does not, to my knowledge, have his own cell phone. It sounds like, based on what the defense attorney said, that he's been borrowing his wife's cell phone. But we do have difficulty contacting him, that's true, but I believe that because he's homeless, he's deserving of this court's understanding in missing a single depot date. Judge, what I would say is that this case is not just being delayed because the victim is not showing up to depositions. There are other witnesses that the defense could be deposing right now, and they have not chosen to do so if you review the record. There's a lot of work to do in this case, Judge. The victim just not showing up to one depot date did not significantly delay this case. I would also point out to the court that my position is that he is a threat to the community based on these charges. So that is my position, Judge.
And Your Honor, if I could respond to that.
Sure.
We are scheduled for a deposition of the witnesses and of the arresting officer on December 12th. We're going to try to do it all at once. We started the process of scheduling those depositions with the witnesses before we had the deposition that was canceled of the alleged victim. And in addition, that's not the only thing that's missing here is not just the depositions. We have not received 911 calls. The alleged victim has never provided medical records. We have requested a copy of the subpoena. that we also have not received. There is a pretty significant amount of very important outstanding discovery in this case. This case didn't just happen. This incident allegedly happened in June of 2022. Now, the officers didn't arrest Mr. Feckety that night because they thought the witness statements matched in some ways, but were different enough that they thought that they needed to go get a warrant. We don't have a copy of that warrant yet. I requested it several months ago. And just to run through the witnesses here, there's an Elizabeth Fife who said that Mr. Feckety was pushing the alleged victim with the truck and then ran him over. A separate witness, I believe it was Emily Ingram, said that the victim was only struck once. And then the Charles Evans, another witness, said that he viewed everything in his rearview mirror and it was about 20 feet behind him. And in addition, last thing would be that the alleged victim was interviewed at the hospital that night. What is in Mr. Turpin's witness statement says that I do want to pursue charges. However, after watching the video, what the alleged victim actually said was that he didn't remember anything and wanted to pursue charges if Mr. Feckety intentionally hit him. And so, Your Honor, this is the status of the case, and it's possibly a long way from being settled, all the while Mr. Feckety, while presumed innocent, is sitting in jail.
So the situation that appears to the court is Mr. Feckety is awaiting trial on a charge of aggravated battery with great bodily harm or with a deadly weapon in this case. While he was out on pretrial release, Judge Oberleeson found probable cause to believe that he had committed a new offense. That case number is 23MM3415, and that's another battery case. So, respectfully, your motion is denied.
I understand, Your Honor.
So it does appear that in the misdemeanor case, which I believe you are also representing.
Yes, Your Honor.
Mr. Feckety, you have a court date coming up within about 2 weeks.
Mm-hmm.
I don't know what Judge Ketchell's philosophy is on the viability of your motion after that misdemeanor is resolved. I can't speak to that. But today, as I'm sitting here, he's out on release and has a new charge. So, denied.
I understand, Your Honor.
Thank you.
Thank you, Your Honor. I believe that's all I have.
Thank you.
Thank you.
Judge, when is this being continued to? When's our next court date? Thank you.
Yeah. All right, Mr. Madden. And Mr. Madden, I believe you are here on
Brock Hammerstone,
case
Your Honor.
number 11. Brock Hammerstrom, 23 CF 389 and 23 CF 447 and 23 CF 1507.
Yeah, ma'am.
All right.
If I had just 1 second. Your
Sure.
Honor. Your Honor, we're here on Mr. Hammerstrom's 3 different cases, and we're going to be withdrawing his previously entered pleas, and he's going to be admitting to the violations of probation in 23 CF 389 and 23 CF 447, and he will be pleading no contest in 23 CF 1507. I have an executed plea agreement, if I may approach.
Yes. Thank
Signed
you.
by all parties.
Thank you so much.
And Judge, the defendant scores 22.3 points. We'll file the score sheet with the court afterwards. That's wonderful. Thank you.
You don't have a score sheet? Oh, you do? Great, thank you. Is that a combined score sheet?
Yes, ma'am.
Okay.
And I've reviewed the score sheet with my client, and it was 22.3. Would Your Honor like me to announce the terms of the plea agreement?
Yes, please.
So on 23 CF 389, Mr. Hammerstrom will be admitting to the violation. He'll be adjudicated guilty. He'll have credit for time served, $100 violation of probation fee, and that fee is to be paid during the probationary period that he'll be going on in 23 CF 1507. In 23 CF 447, he will also be admitting. He'll be adjudicated guilty, credit for time served, another $100 violation of probation fee. That will also be due during the probationary period on the 23 CF 1507 case. He's going to be pleading no contest to all counts as charged in 23 CF 1507. On count 1, he will be adjudicated guilty. He will be placed on 1 year of drug offender probation, followed by 2 years of standard probation. He will pay the mandatory fines and court costs. Probation will terminate after the second year of probation. So after he does 1 year of drug offender probation and does the next year of standard probation, if he has completed all terms, no new violations, then probation will terminate at that point. The court will reserve jurisdiction as to restitution for 90 days. I don't believe any of it has been requested as of this point, but jurisdiction will be reserved. On count 2 and 3, he'll be adjudicated guilty and be given credit for time served.
Fines and court costs on 1507.
I'm not sure exactly what those are, Your Honor. I know that there are some, but I'm not sure exactly what the number is.
615.
And then on 389, just, okay, same.
That's right.
What's the cost of supervision?
I believe it's $40 a month, Your Honor.
Do I have probation here today?
Yes, ma'am. Yes, ma'am.
Great, thank you.
So,
Then, Your Honor, for clarification on the first 2 cases, the VOP cases, are those revoke and terminate, or are they being modified and reinstated?
revoke and terminate. I apologize.
Thank you. So he's not being sentenced to a new term of probation on 23 CF 389 or 23 CF 447?
No, Your Honor, that probation is being revoked and terminated, and he's going to be put on a new term of probation on the 1507 case.
Okay, and then the fees in the 2 violation of probation cases I just listed, those are to be paid during his probation on 23 CF 1507?
Yes, ma'am.
Okay. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you'll state your name, please.
This is Brock Hammerstrom.
Thank you, sir. So in case 23 CF 389, you're accused of violating your probation. In 23 CF 447, you are also accused of violating your probation. And then in the new law case, 23 CF 1507, you are charged with possession of a controlled substance. That's a third-degree felony. You could get up to 5 years in prison for that, maximum $5,000 fine. Count 2, possession of a controlled substance, less than 20 grams of cannabis. That's a misdemeanor. You get up to a year in jail on that charge. And then on count 3, leaving the scene of a crash involving property damage, that's a second-degree misdemeanor. You could get up to 60 days in jail on that charge. Do you understand the charges and
Yep.
maximum penalties, sir?
Yes, ma'am.
Have you had a chance to talk to your lawyer about the charges in 23 CF 1507 and the allegations that you violated your probation in the other 2 cases?
Yes, ma'am.
Did you read the plea agreement?
I did.
Is this your signature?
Yes, ma'am.
Do you understand the rights you give up when you enter a plea?
I do.
You understand that you are giving up your right to have a trial on 23 CF 1507?
Yes.
You understand that you're giving up your right to have a contested hearing on 23 CF 389 and 23 CF 447?
Yes, ma'am.
Is anybody forcing you to enter the plea today?
No, ma'am.
Has anybody promised you anything other than what's reflected on your plea agreement?
No, ma'am.
Have you had any drugs, alcohol, medication, or any substance in the last 24 hours that affects your ability to understand what's going on?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on?
No, ma'am.
Are you happy with your lawyer?
Yes.
Did he answer all of your questions?
Yes, ma'am.
Any DNA?
No, ma'am. Not that the defense is aware of.
I have a score sheet that reflects 22.3 total sentence points. State, do you agree with that?
That's correct, Judge.
Defense?
Yes, Your Honor.
Factual basis for the plea in 23 CF 1507?
We would admit, Your Honor.
The court finds a sufficient factual basis based on the documents in the court file as well. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
In case 23 CF 389, are you admitting to violating your probation?
Yes.
In 23 CF 447, are you admitting to violating your probation?
Yes, ma'am.
Is that as to all counts? I didn't look at the affidavit lately. Is there more than one count, Mr. Madden?
Yes, ma'am, but it's still...
Okay. Sir, are you admitting to all counts in the affidavits that you violated your probation in those two cases?
Yes, ma'am.
In case 23 CF 1507, how do you plead to count 1, possession of a controlled substance?
No contest.
Count 2, possession of a controlled substance less than 20 grams of cannabis?
No contest.
And count 3, leaving the scene of a crash involving property damage?
No contest.
Have you discussed the terms of the plea with your lawyer?
Yes, ma'am, I have.
Do you agree with the terms that he read out regarding your sentence?
Yes, ma'am.
Is there anything he said you don't understand?
No, ma'am.
All right, I accept your plea. I find it was freely and voluntarily entered as to all counts and all cases. And I am going to sentence you in accordance with your plea agreement. So in case 23 CF 389, probation will be revoked and terminated. There is a $100 violation of probation fee that's to be paid during your probation on 23 CF 1507. In 23 CF 447, again, revoke and terminated. Defendant will be adjudicated guilty on all counts on both 23 CF 389 and 23 CF 447. There's a $100 fee on 23 447 as well. That's to be paid during probation on 23 CF 1507. And in counts, let's see, 23 CF 1507, count 1, adjudication of guilt, terms and conditions of probation as stated on the plea agreement. However, I do want to add to the sentence that it says probation will terminate after the second year of probation if all terms are completed and there are no violations. So if you violate your probation, you would not be eligible for this automatic early termination after the second year. Do you understand that?
Yes, ma'am.
And court is reserving jurisdiction regarding restitution for 90 days. Cost of supervision is $40 per month, $615 fines and court costs. Count 2 will be adjudication of guilt, credit for time served. Count 3, adjudication of guilt, credit for time served. I'm signing the score sheet. And is there anything that I have failed to cover regarding the plea?
I don't believe so, Your Honor.
Anything from the state?
No, Your Honor, thank you for your time.
Sure.
Your Honor, just a point of clarification for the cost in the VOP cases.
Yes.
There's still court costs that are outstanding in both of those cases, or is there going to be rollover in the new case to be paid as well?
I would ask that they would, Your Honor.
Thank you for bringing that up. So yes, any unpaid or outstanding fines or costs or fees in either 23 CF 389 or 23 CF 447 will need to be paid as a condition of probation in 23 CF 1507. I'm writing that on the plea agreement. Sir, you have 30 days to appeal the judgment and sentence of the court. If you wish to appeal and you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir.
Thank you.
When are you, is this the only thing holding you in jail?
Yes, Your Honor.
Okay, you should get out. And probation, does he need to report as soon as he gets out?
If he's able to report by 4 p.m. today, if not, it'll be 8 a.m. Monday morning.
Monday morning?
Close to.
Yeah, I would ask that he be, I don't know how soon he'll get out, so I would ask that he be given until 8 a.m. Monday morning.
8 a.m. Monday morning. Unless if he gets out prior to 4 p.m. today and can make it to the office.
Okay, so sir, if you, and your office is in Crestview?
No, ma'am, Fort Walton Beach, 13 Kelly Avenue.
Okay. So, sir, if you get out by 1 o'clock today, you need to go report today.
Okay.
If it's after 1 o'clock, you need to be there at 8 o'clock Monday morning. You understand?
Yes, ma'am.
If you fail to report, that's a violation. Do you understand?
Yes, ma'am.
Thank you. Good luck to you, sir.
Thank you.
Thank you. Thank you, Mr. Madden.
Thank you, that's all I had. I'll be excused.
Thank you. Mr. Skavaski? Good morning, Mr. Skavaski. You're here on 21 CF 3079, Elizabeth Damron. She also has 23 CF 840. I believe those are the only two. Is that right?
Yes, Your Honor. Ms. Damron's standing next to me. This matter is before the court on a status conference as it relates to competency restoration. Judge Ketchell is very familiar with the case, but may we approach the bench, prosecutor and myself?
Sure, and could I please get Ms. Fosso to state her appearance on the record?
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Blackcomb Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
All right, so we're here on a status conference. And Ms. Basso, would you please announce what you're requesting?
Yes, ma'am. The defendant is currently on pretrial services. We're asking the court to remind Ms. Dameron that she needs to continue to comply with pretrial services. We're asking that Ms. Dameron present herself to Dr. McDonald for a reevaluation as to competency and any mental health concerns and treatment.
And defense?
Yes, Your Honor, we agree with that, and that I would prepare the order, and that once the order is signed, I would contact Dr. McDonald within 10 days to work out a schedule for the reevaluation.
Thank you.
Just one moment.
Sure. Do I have anyone from pretrial here?
Not necessary. That's it. Thank you, ma'am.
Oh, so ma'am?
Yes, ma'am.
I am ordering you to comply with pretrial services.
Yes, ma'am.
I'm ordering you to go back to Dr. McDonald for a reevaluation.
Yes, ma'am.
For competency and for any recommendations regarding mental health treatment. The attorneys are going to prepare an order, and your attorney is going to reach out to Dr. McDonald to try to schedule that appointment after I sign the order.
Yes, ma'am.
And you'll be notified when that appointment is. I'm ordering you to attend that appointment whenever you're notified that you need to go. You understand?
Yes, ma'am.
Anything else
Thank
I
you,
need to
Judge.
address?
No, ma'am. We just want to make sure that Ms. Dameron and her attorney understand that that Dr. McDonald's schedule will very likely be limited, so her first availability, we're asking that take place.
Yes, first available appointment. Your attorney will notify you when that is. I'm ordering you to attend once your attorney notifies you of the date and time of that appointment. All right, when does she need to reach out to pretrial?
Your Honor, she's actually already on pretrial. We just want to make sure that there's no question that she needs to continue to comply with that. I don't believe that she's been released. She's still on pretrial.
She doesn't need to reach out to contact them?
Unless she's been directed by them to check in.
She's been in regular contact.
Okay.
Kelly, I think is her first name.
Okay, we'll continue to comply with pretrial services
Yes,
then,
ma'am.
ma'am. All right, thank you. Good luck to you.
Thank you, Judge.
Thank you.
Thank you, Judge.
May I be excused, Judge?
Yes, thank you. Mr. Rare?
Good morning, Your Honor.
Good morning.
Your Honor, for the record, David Rare here for Mr. William Elliott. Mr. Elliott. Your Honor, before the court in 23 CF 338, there's currently outstanding a violation of probation warrant for Mr. Elliott, and he's here before the court to address that today. The basic allegation for the violation is for a new arrest in Escambia County.
If you'll just bear with me 1 second.
Certainly.
Get my paperwork out. So this is 23 CF 338. It's number 10 on the docket. Could I please get appearances from the state?
Yes, Your Honor. Taylor Sharpless from the state.
All right, and it looks like, Mr. Rear, you're covering for Mr. Lupella?
Yes.
Okay, thank you. And Mr. Lupella had filed a motion to set bond. All right, go ahead.
And thank you, Your Honor. The basis for the alleged violation is a new arrest in Escambia County, possession of controlled substance and suspended license and paraphernalia. My understanding of the facts, I believe his next court date for that is February in Escambia. My basic understanding for that is he went to go pick up his car after his prior incarceration. He was pulled over, and there was a residual drug amount from prior to his original incarceration in this case, not of new drugs. While he's been out, Judge, his probation, he was sentenced to complete the Master's Touch Ministries program. They're located in Escambia County. Part of that program is his participation, but also in his time there, he has been made an administrator with the program. The CEO of the program is Miss Melanie O'Connor, and she's present today. We expect to call her as a witness also. And I believe she would testify to the role that he has played so far with the program, her need to have him out to continue to work with her to build the program. They have some new buildings and construction projects coming through the pipe to build the program. And as far as bond, we would ask the court to set a signature bond if the court would allow. We would not oppose pretrial services and drug patch as a condition of bond. He has been clean since being out. The drugs that were found allegedly in his car were old, they were not new, and he would have no problem completing the drug patch. If I could call Miss O'Connor. If you could stop about 6 feet that way. And Judge, is it fine if she stands here at the podium to address the court?
Sure. Ma'am, when you get settled, if you'll just raise your right hand. Do you
Good morning,
swear?
Judge.
Good morning. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. Go ahead, Mr. Rear.
Ma'am, if you could you state your full name for the record?
Melanie Kanan O'Connor.
And ma'am, what is your relationship with Master's Touch Ministries?
I'm the founder and CEO.
Could you briefly just tell the court what the program is, what its function is?
Yes. 30 years ago, God gave me this house. I didn't know the purpose of it, but He did. And it happened that it became a halfway house. And so we take prisoners straight from out who've been there 20, 30, 40 years even into my home. Now it's grown into 6 homes, and we need more. And it takes one to know one. Now it's grown into a world of people using drugs, and I need Mr. Elliott, who's now straight, to help me. He's under my wing with me every moment. I know where he is every day. He's like my right arm man, and at the age of 76, I know that God didn't call me to retire yet. But I need him to help with the new structure that we've begun, doing drug tests, sending people to Most Excellent Way programs, and we have Bible study at home every week. We've had that for years. And we take people to church, and I pray over them, and all kinds of things happen there. But the main thing is that the ones who want to enter back into society as a respectable citizen can do so and have the opportunity to do so. And this is why we need Mr. Elliott, to bring some structure to Master's Touch program. And yes, it is true that he is a major part of building these 3 houses on the land.
Thank you, ma'am. I don't have any further questions after that.
Does the state have any questions?
No, ma'am, I don't have any questions for this witness.
Thank you for all that you're doing, ma'am.
And thank you. And I do need to say that I was a part of getting that his truck back out of when it was in confiscation, you know. And so I was there and provided one of my men to drive it.
Right, just to summarize, you were there when you collected his vehicle with him?
Yes.
Okay.
And, you know, nobody knew that anything was in the truck, but it was unfortunate that my manager at the place where he was staying yelled and screamed at him because he was making too much noise cleaning out the truck. And so then after that, he was thirsty, and I refused him a ride up to the station to get something to drink, and he had a flat tire. And he wanted to go get air, and it just happened, a whole bunch of things together that could have happened differently, and this never would have happened.
And Ms. O'Connor, have you had any instances in which she's been found with drugs or narcotics in your time with him?
No, and believe me that after so many years of doing the same thing, I know he's been clean. Absolutely, no doubt about it.
And that's all the questions I have, Judge.
State anything?
No, Your Honor, just a small amount of argument, but nothing for the witness.
Okay. Thank you, ma'am.
Thank you very much.
Mr. Rear?
And Judge, to follow on that, what we're requesting the court to do is consider a signature bond of the warrant for Mr. Elliott to allow him to go back to the ministry program. He understands he'd have to go through the formal booking process. And Mr. Elliott, you can come back and stand over here at the podium. And again, he's already on probation, Judge, so he has been reporting to his officer, Ms. Turner, over in Escambia County. But if the court would like double assurances and to ensure that the drug patch is in place as a condition of release on bond pending the BOP being resolved, again, we would not object to pretrial services being on top of probation to ensure the drug patch is installed, typically 24 hours, or within 24 hours of posting bond.
Thank you. State?
Yes, Your Honor, so I do understand Mr. Rear's argument, and I do understand the concern of the director of the Master's Touch program. However, this would be the second violation that Mr. Elliott has had, so that does concern the state. The other concern of the state is that drugs were found allegedly in his possession, which is an Escambia County case that obviously I don't have, but the probable cause narrative is in the violation report. On Your Honor, it states essentially that he got pulled over. There was probable cause states there was an admission that there was some marijuana in the car. A probable cause search of the car commenced. That's when the Escambia County deputy found the small amount of methamphetamine and the spoon. He is on probation for a second DUI outside of 5 years. So the state is concerned about him being, even though I understand he's going to say that it was something that existed prior to him playing out this case, or something that wasn't recently acquired. The state does have concerns about this, especially since the probable cause doesn't state that he explained to the deputy that it existed prior to that day. It wasn't recently acquired. Probable cause just states that he admitted to ownership of the small amount of methamphetamine in this, I believe it was a spoon. So the state does have concerns, but would leave the bond conditions or any bond up to the discretion of the court.
Anything further?
I would just note that the state's going off a probable cause affidavit, not full reports or video from the case and actual conversations had. Additionally, as far as driving concerns, obviously despite Ms. O'Connor going out there with Mr. Elliott to retrieve the car after he was released previously, obviously he's not driving, he's with the ministry's program, and she was transporting him here today to be before the court to address the VOP.
So I reviewed this case, getting ready for today. This is the second violation of probation. In fact, it appears that the first violation of probation, which was also a new law, if I'm not mistaken, that was just resolved about 4 or 5 days before this current arrest.
4 days.
And the charges in the Escambia case,
Possession, paraphernalia, and suspended license charge.
driving while license suspended or revoked, and this arrest just occurred within just a few days after resolution of the first VOP. The first VOP, violation of probation, was for new charges in Walton County, including driving while license suspended or revoked. And Judge Ketchel, who is assigned to this case and is familiar with the case, issued a warrant and set that at no bond. And in light of these circumstances, I'm not inclined to deviate from Judge Ketchel's warrant and his decision not to grant bond, especially because this is a second violation of probation allegation. So respectfully, the motion is denied.
Understood, Your Honor.
Thank you.
And Your Honor, as far as next court date, I don't believe we have one set. Can we add it to the docket for December 13th pretrial for a status hearing?
This is a DOP.
It is 14th.
You said the 14th?
Ms. Sharpless.
December the 14th?
December 14th.
I did see your denial.
Understood. Thank you.
He did file a denial with you.
Okay, great, thank you. Thank you.
Thank you, Your Honor. That's all I have.
Thank you, sir. Thank you.
Your attorney can get anything for you. Head this way.
Just $100 down my wallet. And she needs this phone probably.
Mr. Catalinic?
Thank you, Your Honor.
Thank you.
Your Honor, could we do Mr. Grimble first?
Go through that door right there.
Let's see if
I
we can
appreciate
get him
it.
out. Sure, let me find your cases. All right, Mr. Grimball, that is number 7 on the docket, 23 CF 377.
That's correct.
Great, thank you. And it appears the defendant is present. And could I get appearances from the state?
This is Noah Lasco on behalf of the state.
Thank you. All right, so we're here on a request to set a bond.
Yes, Your Honor, it's on a violation of probation. Your Honor, back on April 3rd, 2023, Mr. Grimble pled no contest to a misdemeanor battery in this case, in this felony case. He was sentenced to 1 year probation, batter's intervention, no violent contact with the victim. He never violated any of the terms of his probation, Your Honor, but he did pick up a new arrest. It was a DUI, was a misdemeanor, 23 CT 2550. He was given a bond on the new charge on the DUI, Your Honor. There were no injuries, apparently. And what we would like to say is that there
There was a refusal on both of them, Your Honor, but specifically we're dealing with this case, and what I wanted to say, he's looking at a maximum of 1 year in jail, Your Honor. He's been on probation for 6 months. He's not a flight risk. He's been a resident of Okaloosa County for a long time. He has strong local ties to this community, and these charges are not violent in nature, Your Honor. I believe he spent some time in jail on this violation of probation. We're asking for a reasonable bond, Your Honor.
What's the state's position?
Your Honor, this motion was set well before the motion was filed. The motion was filed yesterday afternoon. I reviewed the motion and am ready to argue. Judge, while on probation, he was picked up for a DUI with property damage. On the scene, he was spotted carrying a cooler full of beer, and he also fell to his knees to attempt to vomit. So while I understand Mr. Cavanagh's position that there is no blow in that case, I'm sure that the state has sufficient evidence to prove the DUI. That being said, Mr. Cavanagh said that he has not violated the terms of his probation. That's not true. This new law violation would be a violation of his probation. It's not unusual for VOPs to be held at no bond, and I ask the court to leave the bond at its current level here. Thank you.
Thank you. Anything
Your Honor basically pled to a misdemeanor. He was on probation for close to 6 months. We're asking for a reasonable bond, Your Honor. I hate to say this, it's Thanksgiving time. He's been in jail for a little bit of time. Like I said, no one got hurt in this situation. He was vomiting, he was sick. But we're not here on that charge, Your Honor. We're here strictly on the violation of probation. He doesn't pose a risk or danger to society, and he's been a resident of this county for a long time.
Thank you. So this is a violation of probation, allegedly. And it's a new law offense, 23 CT 2550. It appears that the charges in that case are DUI, it's with injury and/or property damage, leaving the scene of an accident.
He didn't leave, Your Honor. He basically walked away.
Okay.
He basically walked to where he was to be safe off the road. I'm sorry for interrupting.
Oh, that's okay. Okay. So looks like he's charged with leaving the scene, if I'm not mistaken. Okay. And then misrepresentation of insurance, that's another charge, and then reckless driving. I'm just listing the charges on the new law offense, 23 CT 2550, and it appears that incident happened on October 26, 2023. So with respect, this is a new law offense that was committed while the defendant was on probation, so the motion is denied.
Very well, Your Honor. Do we have a court date on the VOP?
Because he did file the denial, it will be December 14th, Mr. Wasco.
Thank you.
Talk to you later.
Thank you. Good luck to you, sir. Yes.
Your Honor, if I may, another case, Jose Fernando Barahona Figueroa, 23 CF 2463. It's a motion to reduce bond.
Yes.
May I approach, Your Honor?
Yes, sure.
Good morning, Your Honor.
Good morning.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
interpreter present. And raise your right hand. Do you swear that you will truly and faithfully interpret the proceedings today?
I do, Your Honor.
Thank you, and just state your name, Madam Interpreter.
Teresa Iribarren.
Thank you. All right.
Your Honor, Randy Catalinic on behalf of Jose Fernando Barahona Figueroa. Case number 23 CF 2463. Your Honor, on November 2023, Mr. Figueroa was arrested for cocaine trafficking, possession of paraphernalia, and driving without a valid driver's license. His bond is currently set at $107,000, Your Honor. He's not a flight risk. He's a resident of Okaloosa County, has strong local ties to this community. Your Honor, he doesn't have any priors. He's never been arrested before. He's been living in this country for 15 years. He doesn't have any type of criminal record. He's never been arrested. He's never been charged with any type of crimes besides this one, Your Honor. He was compliant with the police, and we approached the bench, Your Honor, and we did discuss some situations on this case that we're working on with the state, and we're asking for a reasonable bond, Your Honor. In this case, we're asking for a bond to be set less. I mean, $100,000 is something that his family cannot do. It might as well be a no bond at this point.
All right, what is the state's position?
Your Honor, the state stands behind the position and the information that it gave to the court at the bench, Your Honor, and at this time would ask for Mr. Barahona Figueroa's bond to remain the same. And if we need to readdress it at a later time, we will do that.
All right. Anything further?
Your Honor, I have nothing else to say.
Okay, let me just confirm the bond. I saw what was set at first appearance, but it looks like the information doesn't include all of those charges. It looks like the possession of a controlled substance charge is not included in the information. Is that correct?
That's correct, Your Honor. The state filed one trafficking charge, Your Honor. It was the state's position that the trafficking charge would subsume the possession charge, which is why the state took no action on the possession charge.
Thank you. And so bond is currently set, if I'm not mistaken, count one, the trafficking charge, which is a first-degree felony, is set at $100,000 cash or professional, and then there are two misdemeanors. Count two is possession of drug paraphernalia. That is set at $1,000 cash or professional, and then the third charge is driving without a valid license, and that one is also set at $1,000 cash or professional. Is that correct?
Yes, sir.
Okay. For a total of $102,000. This is an extremely serious charge. I don't have to tell you that. It's extremely serious. I heard what you said about ties to the community, but from my review, it doesn't appear that the defendant has a valid driver's license, or perhaps could be substantial flight risk based on his immigration status. Correct me if I'm wrong on that one.
Your Honor, the last thing, we have an immigration attorney working on the case.
Okay.
If I have to specify the person's name, I will. At this point, I wouldn't like to. It's not, according to what I'm saying, according to his attorney, he's not a flight risk, Your Honor.
Okay. So, based on the seriousness of the charge, Ms. Sharpless, what is the minimum mandatory that charge would carry?
Your Honor, I believe that this is the 15-year minimum mandatory. Give me just a second, I can check that.
It is, Your Honor.
With respect, I'm denying the motion at this time. That'll be without prejudice. If you have some other grounds or something develops in the case that would be appropriate to present to Judge Ketchel that the circumstances are different than they appear to be right now, then of course you can refile. But as things sit here today with the seriousness of this charge and the immigration situation, which to the court appears to be a
Yes, Your Honor.
flight risk,
Yes, Your Honor.
the motion is denied.
Thank you, Your Honor.
Thank you.
I appreciate it.
Thank you, sir.
See you.
And when is this next court date? February 12th. February 12th.
Sorry.
February 12th is the next court date.
Your Honor, my last case is Mr. Scott Altilio.
Yes.
He's here present, Your Honor.
All right.
May I approach? I'm sorry.
Of course. Thank you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
23TR3228, 23TR3229, and 23TR3230. You're wanting to reset for a full resolution?
To allow time for the state to get their restitution, Your Honor. If we can have the closest court date, my client is anxious to close the state, to close this case. Apparently, he's given me the money already, but it might be too much money for the restitution, so we're trying to work that out for his best interest.
So I believe
The earliest court date that you have,
December 14th is Judge Ketchel's earliest date.
December 14th is good.
Okay, so 9 o'clock? 9 o'clock, December 14th. All right, good luck to you, sir.
Thank you, Judge DeSilla. Happy Thanksgiving.
Same to you. Thank you. Ms. Graham?
Good morning, Your Honor.
Good morning.
Trisha Graham on behalf of Crystal Kanazawa, who's approaching.
All right.
In case 23CF001123.
Yes.
Your Honor, we've reached an agreement for the referral to pretrial intervention program. I have the paperwork signed by the state and my client. Shall I approach with that?
Yes, thank you.
And Your Honor, Ms. Balso on behalf of the state, and that is the state's agreement.
All right.
Sure, I can drink.
All right, ma'am, if you'll just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down. Could you state your name, please?
Crystal Canizaro.
Thank you, ma'am. You're here on one count of kidnapping of a minor, interfering with custody. I believe that's a third-degree felony. Is that correct?
That is correct, ma'am.
Thank you. Have you had a chance to talk to your lawyer about that charge and any defenses you might have?
Yes, I have.
Did you read the agreement that's titled Referral to Pretrial Intervention Program?
Yes, ma'am.
Is this your signature on page 2?
It is.
Do you understand the rights you give up when you enter a plea?
Yes, I do.
Do you understand you're giving up your right to have a trial on this case?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you to enter the plea?
No, ma'am.
Has anybody promised you anything except what's on this agreement?
No, ma'am.
Are you happy with your lawyer?
Yes, ma'am.
Did she answer all of your questions?
She did.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours that affects your ability to understand what's happening?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on?
No, ma'am.
Any DNA?
No, ma'am.
Okay. I do find a sufficient factual basis based on the arrest report that's in the court file. Ma'am, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
I do.
All right. So how do you plead to count 1, kidnapping of a minor, interference with custody?
No contest.
Thank you, ma'am. I accept your plea. I find it was freely and voluntarily entered. I am going to ratify the state's referral to pretrial intervention. Now, there are certain terms and conditions, and those are cost of prosecution, $100, court costs, $667, $150 public counsel fee. There will be a cost of supervision at the normal rate. What is that normal rate? Does anybody know?
$40 1 month.
$40.
Surcharge.
$40 per month, cost of supervision. I'm writing that on the agreement.
It's in the other portion of the plea.
Oh, sorry.
That's okay.
Then you agree to comply with any and all DCF or Families First Network or Child Protective Services recommendations and case plans, if applicable. You are to attend and successfully complete parenting classes. Is there a deadline to enroll in that?
Ma'am, we usually ask to be done within 30 days.
Okay, you need to enroll within 30 days and you must successfully complete the classes. I wrote on here, enroll within 30 days. There is to be no contact with the victim. What is the victim's, what are the initials?
It's ACR.
That's correct.
No contact with the victim, ACR. And you may request early termination after 9 months. That's if you've completed everything, paid everything, you're not in any, you haven't committed any violations, and you've been a model pretrial intervention person. And did I read the terms and conditions correctly?
Yes, sir.
All right. So, ma'am, if you comply with the terms of pretrial intervention, this is a golden opportunity. You can have these charges or this charge dismissed if you comply.
Yes, sir.
If you fail to comply, or if you violate the terms, you've already entered a plea. You will come back to Judge Ketchel or to me, since I've taken your plea, for sentencing. And whatever sentence is imposed would be entirely up to the judge. Do you understand that?
I do.
This charge carries up to 5 years in prison. Do you understand that?
Yes, Your Honor.
So I'm encouraging you to take this program very, very seriously. It's a great opportunity to have this charge dismissed.
Yes, Your Honor, thank you.
If don't take it seriously, you'll come back in front of the judge and you could be facing prison time. You understand?
Yes, Your Honor.
Good luck to you, ma'am.
Thank you.
Thank you, Ms.
Thank you,
Brown.
Your Honor. Do we have a control date or?
Oh, let's see.
We can do one, but normally we just, because she's entered a plea, she then meets with probation. The paperwork that judge has, probation will sign off on and e-file it.
Okay.
And probation, does she need to see you right now?
Actually, she will take a copy of the PTI agreement directly to the probation office, and Officer Perez, who is our pretrial intervention officer, will go over it with her, sign it, and then file it appropriately.
Does she need to report today?
Yes, ma'am.
Okay, so ma'am, when you leave the courthouse, you need to go straight to probation.
Yes, ma'am. Yes, Your
Okay?
Honor.
Good luck to you, ma'am.
Thank you.
I'll take that, thank you. And then if you'll hand this back, just to let you know, they'll sign off on it, you know, e-file it. Okay, thank you.
Thank you. And Your Honor, may Ms. Sharkles and I approach on a different matter?
Sure.
This is your
Do you have the case number?
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law.
Yes, 22 CF 2740. All right.
Motion to set bonds, Your Honor. Mr. Bellinger was arrested, I believe it was July of this year, for possession of cocaine. Your Honor, Mr. Bellinger has lived in the area for quite some time now. I believe you do have family in the area, correct? Yeah. Has family in the area, so he does have a place to stay. I believe he has a job waiting for him if he were to be granted bonds. Essentially, Your Honor, Mr. Bellinger is not a flight risk. He does have ties to the community. Your Honor, it was a nonviolent offense, so I don't believe he poses any danger to the community. We would ask for a reasonable bond in this matter.
What's the state's position?
Your Honor, the state would oppose reducing or reinstating or giving any bond on the violation of probation. The violation was for a new law charge, which is 23 CF
1567.
Yes, Your Honor, which the state has charged him with sell, manufacture, deliver cocaine. Your Honor, he got a new offense, sell, manufacture, deliver involving cocaine while he was on probation for possession of a controlled substance. I believe the controlled substance alleged in that case was also cocaine. So the state doesn't have any faith that there are any conditions of bond which he will be able to comply with, because he continues to get new charges.
And Your Honor, we would ask that the bond, in order to make the court comfortable, we have no problem with community control sanctions as part of the bond.
So, anything further?
No, Your Honor.
All right, thank you. So in the current case, 22 CF 2740, it appears that Mr. Bellinger was placed on probation February 13th, 2023, and this new law offense is alleged to have occurred on July 15th, 2023, and it's a similar charge. With respect, the motion is denied. This is a violation of probation. It's a serious charge. He's not entitled to a bond on a VOP.
I understand, Your Honor.
Thank you.
Thank you.
Thank you.
Good morning, Your Honor.
Good morning.
Louisa Doug for Ryan Asbury.
Yes.
In 23 CF 1564 and 23 CF 465.
Yes, thank you.
Being in contact with the state's going to dismiss the violation of probation, and we are going to stipulate to an order modifying probation. His probation will be modified to include a substance abuse evaluation and recommended treatment, and that evaluation shall be completed within 60 days. I do have an order for that as well.
Your Honor, that is the state's agreement.
Okay, so let me pull up the case and take a look. And is there a written agreement, you said, or?
Well, the BOP is being dismissed, and I have an order modifying the probation, if I may approach.
Sure, yes, thank you. Thank you so much. All right, so Ms. Sharpless, does the state have an announcement regarding the violation of probation affidavit?
Yes, Your Honor. At this time, the state would dismiss the violation, and that it is the agreement of the state and the defense that an order modifying his probation to include a substance abuse evaluation and treatment should be entered by the court.
All right. And, sir, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. Just state your name.
Ryan Asbury.
All right. You've heard the agreement announced by your attorney and by the state.
Yes, ma'am.
Do you agree to the agreement that the state's going to dismiss the allegations that you violated your probation, but your probation will be modified to include a substance abuse evaluation and any recommended treatment, and you have to do that evaluation within the next 60 days?
Yes, ma'am.
Is that your agreement as well?
Yes, ma'am.
Is there anything you don't understand that's been discussed today?
No, ma'am.
All right, I will go ahead and sign the order that's been agreed upon by the defense and the state and modify the defendant's probation to include a substance abuse evaluation and must successfully complete any recommended treatment, and that evaluation must be completed within the next 60 days. And does he need to report today or do anything else today?
I think he's been reporting probation, but he can check with him before he leaves.
Thank you.
That's all I have, Your Honor.
Thank you. Good luck to you.
Your Honor, I do think that probation is going to instruct him that he needs to report today, just for the record.
All right, sir. You need to report today, or else that would be a violation.
Okay, I'm already in Walton, CC.
Well, probation, do you want him to report today?
Your Honor, could I call a couple of out of custody before we call the inmates, just for continuances? Brent J. Buchter. Mr. Buchter is approaching docket number 32. He has two cases that are in circuit court. One of them has a CT number, but they're both in this court, 23 CF 491 and 23 CT 1165. And at this time, I would like to enter a denial on Mr. Buchter's behalf. He's getting Keaton and possibly other evaluations working with the PD investigator. I've given him that information. And so if we could continue this to perhaps December 14, if that's available.
State?
Your Honor, that's fine with the state.
Does that date look good? All right, December 14th at 9. And do I need to address bond?
No, ma'am. He's out.
Oh.
We're sorry. Yeah. No, I don't think we have any pending issues. So that's a good question, Your Honor. Didn't mean to.
Good luck to you, sir.
Joke. Okay, thank you.
Thank you.
Appreciate it. Your Honor, next is Daniels. Mr. Christopher Daniels is 35, docket 22 CF 2935.
All right.
Your Honor, Mr. Daniels is approaching. I need to enter a denial on his behalf. There are some financial issues, but he is going to be, I talked to probation. He was supposed to do batter's intervention, and he hasn't been able to do that. Our position is for financial reasons, but if we can get a continuance, does the state want to do a December 14 to just make sure he's going to, Bridgeway is available for batter's intervention, which might be cheaper than the other options, so.
December 14th
Okay.
is fine with the state. I'll be here.
All right.
So the next court date is going to be December 14th at 9 a.m., but you need to go ahead and call
I'll have
Bridgeway
that.
right away. All right, thank you.
Thank you.
Appreciate it. Those are my two out of custodies, the others are inmates, Your Honor. Thank you.
Thank you. Do I have regional?
Judge Greenhart on behalf of Regional Conflict Counsel. I've got a couple, most are in custody though.
Okay.
The first one, number 17 on the docket, Sierra Banks, female.
Thanks.
All right, yes, that is 19 CF 1454, 19 CF 1459, 21 CF 454, 22 CF 2784, and 23 CF 1170.
Yes,
Did I
ma'am.
get that right?
Yes, ma'am.
All right.
Judge, as the court stated, she's got a number of cases that are on today's docket. We had set it for status to see if we could come to a resolution. I think there is still one outstanding issue that prevents us from resolving it today. If we can set this for the December 13th pretrial conference, I'm fairly certain we can resolve it that cycle. This is Sierra Banks.
Yes, ma'am. I guess it's 23 CF 1170 new. Okay.
That is a newer charge, but yeah.
Madam Clerk, there are VOPs and new charges, so pretrial is fine with the state, Your Honor.
All right, so December 13th. Anything else I need to address?
No, Judge.
All right.
The next one should be Tavoris Berry, number 18 on the docket.
Barry?
Yes, sir.
All right, 23 CF 834.
Yes, Judge, if I may have just a moment to have Mr. Berry sign this.
All right.
Is this still what you? Judge, Mr. Berry is before the courts on 23 CF 2170. However, he does have a new law charge as well, 23 CF 8, sorry, the one that's on the docket today is 23 CF 834. The new law violation is 23 CF 2170. We'll be resolving both of those this morning if the court will permit. The new charge is a felony battery. The charges before the court this morning is a VLP on a felony battery. He'll be entering a plea of no contest. On the new charge, he'll be adjudicated guilty, placed on 12 months of community control. That will be followed by 2 years of drug offender probation. There will be a curfew of 7 p.m. to 7 a.m. He'll have to attend and complete a substance abuse evaluation and any recommended treatments. Be assessed $967 in court costs, $150 cost of defense, perform 24 hours of community service work, maintain employment or 5 job applications per week. With respect to the VOP, 23 CF 834, there will be a modification to 12 months of community control, followed by the balance of probation on drug offender probation with a curfew of 7 p.m. to 7 a.m. to run concurrent, and he'll be required to complete the outstanding requirements. If I may approach, Judge.
Yes.
Your Honor, that is the state's agreement.
Has the state contacted the victim?
Yes, Your Honor, and just for the court's knowledge, the victim has contacted the state and requested the charges dismissed in the new charge. The victim and the VOP and the new charge are the same victim. She's contacted asking the state to dismiss those charges. The state's unwilling to do that, but this is the state's compromise, given that the victim does not wish to see him go to prison or to jail. Your Honor.
All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. State your name.
Tavares Berry.
All right, sir. In case 23 CF 2170, you are charged with felony battery. That's a third-degree felony, and it carries a maximum of up to 5 years in prison. Have you had a chance to talk to your lawyer about that charge and any possible defenses?
Yes, ma'am.
And in 23 CF 834, you're here on an allegation that you violated your probation. In that case, the underlying charge is also felony battery, which is also a third-degree felony, could land you up to 5 years in prison. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you read the agreement?
Yes, ma'am.
Is this your signature at the top of page 4?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
You understand that in the new case, 23 CF 2170, you're giving up your right to have a trial?
Yes, ma'am.
Do you understand in 23 CF 834, you're giving up your right to have a contested hearing on the allegations that you violated your probation?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything that's not reflected on the agreement?
No, ma'am.
Are you happy with your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on?
No, ma'am.
I've been provided with a score sheet that reflects 24.9 total sentence points. Is that correct, State?
Yes, ma'am, that is correct.
And defense, do you agree with that score sheet?
Yes, Judge.
On the new law case, is there any DNA?
There was no DNA evidence that the state's aware of that would exonerate or implicate the defendant.
Thank you. I do find a sufficient factual basis based on the reports in the court file. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
Has he already been convicted of a felony, or is this first conviction?
I apologize.
Your Honor, I reflect that he was adjudicated guilty when the violation originally occurred. The charge that the violation is on, he was adjudicated guilty at that time, is what my records reflect.
Yes, sir. Yes, ma'am.
Great, thank you. So, sir, on 23 CF 2170, how do you plead to the count of felony battery?
No contest.
And, sir, on 23 CF 834, how do you plead to the allegations that you violated your probation?
No contest.
All right, I accept your plea on both cases, all counts, and I find that it was freely and voluntarily entered. As to 23 CF 2170, I am adjudicating you guilty of felony battery in accordance with your agreement. I am sentencing you as follows: 12 months community control, followed by 2 years of drug offender probation with all of the terms and conditions that go along with that. There will be a curfew from 7 p.m. to 7 a.m. You are to have a substance abuse evaluation within the next 60 days, and you must successfully complete any recommended treatment. There will be $967 in court costs, $100 cost of defense fee, 24 hours of community service work. I'm going to require you to complete that at a minimum of 3 hours per month, beginning in January 2024. You are to maintain employment or submit 5 job applications per week. Did I miss anything on 23 CF 2170?
No, ma'am.
Your Honor, probation would request that curfew may be adjusted for school or work purposes.
Of course, but you need to get permission from probation. Do you understand that?
Yes, ma'am.
And case 23 CF 834, we are going to, in accordance with your plea agreement, restore you to probation and modify that probation. Is that correct?
Yes, ma'am.
All right. And the modification is 12 months community control, followed by the balance of supervision will be on drug offender probation, and the terms of that community control and probation are concurrent to 23 CF 2170. Same curfew, and you must still complete all outstanding requirements of your probation that was originally imposed in 23 CF 834 and any subsequent modifications. What about additional costs on this case?
Yes, Judge, with respect to the violation of probation fees, I think it's $50 VOP fee and it's $100 VOP fee and the cost of prosecution.
That is the fee. It's just one $100 VOP fee, which is the prosecution.
Oh, okay.
And then the court appointment.
So as to 23 CF 834, there will be a $100 cost of prosecution, violation of probation fee, also a $100 cost of defense fee. Now I'm seeing that on the new law case, 23 CF 2170, it's a $100 cost of defense. Was there an application fee?
Yes, Judge, it should be $150. I apologize if my writing is not legible.
Okay, so I think I announced a $100 cost of defense on 23 CF 2170. That's actually $150 because there's the application fee, but you don't have to pay the application fee on both cases. You do just have to pay the PD fee of $100 on each case. The $50 application fee is imposed on the new case, 2170. Did I cover all of the terms and conditions?
Yes, Your Honor.
State anything I've left out or failed to address?
No, Your Honor, that's the entirety of the agreement.
All right, and no objections to the score sheet. So, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir. And is this the only thing holding you in jail?
This is the only thing, Judge.
You should get out today. If you get out prior to 1 o'clock, you need to report today. Is that correct, probation?
Yes, ma'am.
All right, and if he doesn't get out, then are you open tomorrow or no?
No, we're not. Not
Okay.
till Monday morning, 8 a.m.
So if you get out after 1 o'clock today, you need to be at probation 8 a.m. Monday morning. Do you understand?
Yes, ma'am.
If you fail to report, that's a violation. You understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
Thank you.
Judge, the next one is Vera Carroll. There's a waiver of appearance in her case, 23 CF 299.
Just 1 second, you'll just bear with me.
Apologize.
What's the name? What's the name?
Fink.
Fink? There you go. Fink?
Just stand by 1 second.
Okay, and I'm sorry, what was your next case?
Judge, this is not my next case. It's actually Vera Carroll, number 19 on the docket, 23 CF 299. There's a waiver of appearance in her case. She's out of state. We're still working on the terms and conditions on her resolution. I've asked to continue this to the December pretrial of December 11th.
Okay, she's out of custody. Okay. Out of custody on the 11th and
All right, so case 23 CF 299, Vera Carroll, that will be continued. Well, I should ask the state, do they object?
No, Your Honor, the state
Okay.
does not.
So continued at the request of the defense to December 11th at 9 o'clock. All right, thank you.
And Judge, this is Austin Fink. He's before the court on 23 CF 1323, a violation of probation. At this time, he's going to admit the violation of probation. The terms and conditions of the proposed plea agreements are a modification of supervision, be assessed credit for time served, be reinstated to complete the original terms and conditions on the balance of supervision, add the requirement of 24 hours of community service work, and he'll be assessed all applicable court costs. If I may approach, Judge.
Yes, thank you.
That is the state's agreement, ma'am.
Great, thank you. Thank you so much. What was the original length of,
It was 11 months, 29 days.
and when was he placed on that probation?
In July of this year?
Yes, sir.
July of this year, Judge.
What is his expected termination date? I'm just trying to make sure that I put on here that he can get his community service done in time. Thank you.
His overall term date is July 9th, 2024.
All right.
That's about 6 months, 7 months. Ain't bad. Appreciate
And what would be, it says all applicable court costs, so that would be what?
I think it's the $100 cost of prosecution and $150 cost of defense. Sorry.
All right, sir, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down and state your name.
Austin Joseph Fink.
Thank you, sir. So you're here on an allegation that you violated your probation in case 23 CF 1323. Have you had an opportunity to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back of the agreement?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am.
State, did you discuss the agreement with the victim?
Yes, ma'am, we did.
Okay, thank you. Is anybody forcing you or threatening you to enter into a plea?
No, ma'am.
Is anybody promising you anything other than what's on the agreement?
No, ma'am.
Did your attorney correctly state the terms of the agreement?
Yes, ma'am.
Are you under the influence of any medication, drugs, alcohol, or any substance that affects your ability to understand what you're doing?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's happening?
No, ma'am.
Have you had enough time to talk to your lawyer?
Yes, ma'am.
Are you happy with his services?
Yes, ma'am.
Do you wish to enter a plea admitting to the violation of your probation and have me impose the sentence that's stated in your agreement?
Yes, ma'am.
All right. So regarding the allegations that you violated your probation, how do you plead?
Guilty.
I accept
No contest.
I accept your admission, your plea rather, and I find it was freely and voluntarily entered in accordance with the agreement between your attorney and you and the state. I am restoring you to the original term of probation and modifying that probation as follows. Credit for time served. You must complete your original terms and conditions on the balance of your supervision, and There will be the additional requirement of 24 hours of community service work. You must complete that at a minimum of 5 hours per month, beginning in December. So that way you don't wait until right at the very end and not
Yes,
get
ma'am.
it done and then possibly violate.
Yes, ma'am.
And you must pay all outstanding fines and court costs from the original charge. And for this violation of probation, there is a $100 cost of prosecution fee and a $150 public defender fee, and there is an adjudication of guilt, correct?
Yes, ma'am.
I'm adjudicating the defendant to be guilty of the underlying charge. Any other terms or conditions that I've left out?
No, ma'am.
Statement. Right. Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. You should get out today unless there's something else holding you. And same thing, report
Yes,
today?
Your Honor.
Okay. So, sir, if you get out, it's unlikely, but if you get out by 1 o'clock, report to probation today. If not, you need to be at their door 8 o'clock Monday morning. If you fail to report, that's a violation. Do you understand?
Yes, ma'am.
All right. Thank you. Good luck.
Thank you, Your Honor.
The next one, Judge, is Stephen James.
All right.
He's before the court on 21 CF 1159 and 21 CF 1666. Judge, I just wanted to point out that there is a discrepancy in the dockets listing his charges. It's actually different from his actual charges.
Okay.
But it's reflected accurately in the terms and conditions of the plea agreement. When he was originally sentenced back in 2021, a lot of these charges were resolved without, there are basically no process. But with respect to today, he's going to admit the violation of probation. There'll be a modification of supervision. His probation is revoked and terminated as to the misdemeanor counts, because there's a number of misdemeanor counts here. With respect to the sole remaining felony counts, there'll be 12 months of community control, weekly year analysis, 1 NA meeting per week, proof to be shown to probation, and that will be followed by the balance of supervision. He'll be assessed the applicable court costs, which is a $100 cost of prosecution and $150 cost of defense, and he'll have to complete the outstanding requirements. He was previously adjudicated guilty, and he'll be adjudicated as well. If I may approach?
Yes, please. Thank you.
I just want to be clear on 21 CF 1159, we have domestic violence, first degree misdemeanor, and on 21 CF 1666, count 2 burglary and count 6 DUI. That's all I have as violation.
I think that there's some more on there.
This one.
This is. But a lot of the probations have lapsed with respect to jurisdiction. Yeah, timed out, yeah.
The VOP on count 2 and count 6.
I just wanted to make sure that those VOPs on the misdemeanors are resolved and they're falling by the wayside at this point for sure. Okay.
So I have the original plea agreement. I'm just trying to sort out the charges too. So it looks like the original charges, several of them were dismissed in both cases. And in 21 CF 1666, it looks like the defendant originally pled to count 2, count 6, count 7, count 8, and count 9. Those would be burglary, unoccupied conveyance, DUI, driving while license suspended or revoked, and then it looks like 2 counts of leaving the scene of an accident.
Yes, Judge.
Okay, and then in 21 CF 1159, looks like the defendant pled to domestic violence battery, and then the 2 child abuse counts, felonies, were dismissed.
Yes, Judge.
Originally. All right. Great. Just want to make sure we're all on the same page.
Yes, ma'am.
The charges that are applicable. And it looks like adjudication was withheld.
Yes, Your Honor. Originally, it was withheld. He had a subsequent violation of probation. My understanding that that was also maintained to withhold, but at this particular point, it would be an adjudication.
I do see that. There was, I did print out the prior violation of probation agreement from December of 2022. Is this his first felony conviction?
This would be his first conviction, yes, Judge.
Is he waiving the PSI?
Yes, ma'am.
Doesn't look like the defendant has signed it.
Oh, I apologize.
That's the problem.
Do you have any last minute questions? You may approach again, please.
Thank you. Thank you so much. All right, sir, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll state your name, please.
Stephon James.
Thank you. So, sir, in both of the cases that are before the court today, that's 21 CF 1666 and 21 CF 1159, you are alleged to have violated your probation. Have you had an opportunity to speak with your lawyer about the allegations that you violated your probation in those cases and any possible defenses?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am.
Did you read the agreement?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
And is that your signature on the back of the agreement?
Yes, ma'am.
Is anybody forcing you or threatening you to enter a plea today?
No, ma'am.
Has anybody promised you anything that's not on the agreement?
No, ma'am.
Did your attorney accurately announce the terms of the agreement?
Yes, ma'am.
And do you agree to those terms?
Yes, ma'am.
Are you currently under the influence of any substances, alcohol, medication, anything that affects your ability to understand what's happening?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's going on?
No, ma'am.
Do you understand that by entering an admission to these violations of probation, you will be a convicted felon?
Yes, ma'am.
And your attorney stated that you're waiving the pre-sentence investigation. Is that true?
Yes, ma'am.
Are you happy with your lawyer's services? Are you happy with your lawyer?
Oh, yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Is there anything that you wanted him to do that he didn't do?
No, ma'am.
Do you wish to enter a plea admitting to the violations of your probation and have me impose the sentence in accordance with your agreement? Do you wish to enter a plea today?
Oh, yeah.
Okay. All right. So regarding counts, well, you're going to have to walk me through this one again.
Yes,
It
ma'am.
looks like in 21 CF 1666, there's only one felony. In
Yes, ma'am.
fact, that might be the only felony
That
as to
remains.
both cases.
Yes, ma'am.
Okay, so are you admitting to violating your probation in case 21 CF 1666?
Yes, ma'am.
Are you admitting to violating your probation in case 21 CF 1159?
Yes, ma'am.
All right. I accept your admission. I find it was freely and voluntarily entered as to both cases, all allegations. So, as to the misdemeanor counts, which are original charges, 21 CF 1666, that's counts 6, 7, 8, and 9. And then in 21 CF 1159, that's count 1, correct?
Yes, Judge.
Okay. Probation in those cases, or those charges, those counts, is revoked and terminated?
Yes.
All right. As to count 1 in 21 CF 1666, I am restoring and modifying probation, correct?
Yes, Judge.
Okay. And credit for all time served. It will be 12 months community control, weekly urinalysis, 1 NA meeting per week, proof to be shown to probation, followed by balance, or I'm sorry, I'm having a hard time reading.
Sorry, it is the balance of probation to follow 12 months of community control.
All right, and
sorry.
So sorry. Could you please announce the terms again? I'm just having a hard time reading it all. No problem.
Followed by the balance of supervision, all applicable court costs, which is the $100 cost of prosecution, $150 cost of defense. He will be adjudicated guilty. He'll be required to complete the outstanding requirements. To make it abundantly clear, the DUI requirements from some of his misdemeanor counts, we're asking to be rolled over into the remaining term of supervision, so that he can have the option of completing those during supervision.
All right, thank you. So the costs, that would be per case, right?
Yes, Judge.
All right. That's $100 cost of prosecution per case, and on 21-1159, it would be $150 defense fee. And in the case ending in 1666, $100 defense fee. Any other terms or conditions or requirements that have not been announced, State?
No, Your Honor.
No, Judge.
And this is no Alaska for the state, for the record.
Thank you. All right, did I cover everything that I
Yes,
need to
ma'am.
cover? All right. Sir, good luck to you. You have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. There is an adjudication of guilt. Is that only as to the felony count?
That's the felony count, Judge. Yes.
There is an adjudication of guilt as to count 1, burglary of an unoccupied conveyance, in 21 CF 1666. Good luck to you, sir.
And Judge, just for Mr. James's clarification, he needs to report either by today if he's released in time, or if not, then he needs it by Monday at 8 o'clock.
Yes, and for the record, we need to have an address of where he'll be residing because he did abscond from supervision.
All right, what is your address, sir?
Right now, I won't have none until at least I get out and see if I still got an address.
Okay, where does that leave us?
What?
And if he's under community control, we have to have an address.
I mean, he's got to be confined to a residence on community control.
My understanding was that he had a residence.
Okay.
Can you announce that address?
5 Beach Drive, Ocean City.
Can you spell that street, please?
Beach, B-E-A-C-H.
Okay.
Yeah, Beach Drive, the 5 Beach Drive lot, I think it's lot 6.
And that's in Fort Walton?
Yes, ma'am.
So if he's being released today on community control,
He would be instructed that he needs to go to that residence and stay there, not all weekend until Monday morning at 8 a.m. when he can report to the probation officer.
so sir, what I heard you just say is that you don't know if you can stay there or what?
I can talk to her. 9 out of 10, last time I talked to her, I asked her about my living situation. She did say I could be able to come, But I just want to make sure it's still okay for him. Let me call.
He believes that he'll be able to go there, but he doesn't know if it'll be a long-term thing. So he anticipates having to move after staying there for a short period of time, is my
We will
understanding.
provide him with an officer's phone number that he needs to contact immediately upon release.
Do you understand that? That you must call probation immediately when you get out, because you're going to have to go to an approved location, address that you've got to give to probation. Your community control starts immediately when you get out. So you must provide an address, and you must be at that address. If somebody shows up from probation over the weekend or on Thanksgiving to that address, they better find you there or you'll be in violation. Do you understand?
Yes, ma'am.
Thank you. So you must call immediately upon your release to provide that address, and I would advise you to be there and not leave. And when he calls, will he be instructed on community control?
Your Honor, when the officer calls, she'll most likely come by and make contact with him as residents. There just needs to be communication established, but you will be locked down to your residence until Monday morning when you report to the probation office to be instructed under conditions.
So do you understand that you cannot leave whatever residence it is that you're going to when you get out of jail?
Yes, ma'am.
Good luck to you, sir. Thank you.
Judge, that's all I have today. Thank you.
Hey, Ruby. Mr. Harper.
Your Honor, if I may have the court's indulgence, Travis Gates of the Defender's Office. I have a flight this afternoon, so I need to try and get through my docket if I can.
Sure.
Your Honor, this is going to be Skylar Holmes.
Okay, what number on the docket?
Should be number 21 on the docket.
I think it's 22. Okay.
Yes, Your Honor. I'm not sure the cases he's in front of the court on. We do have 3 cases that are VOPs, 23 CF275, 23 CF131, and 22 CF2141.
Okay.
And then he has 23 CF2387 that's scheduled for Monday at 11. At this time, we're going to enter a denial on the violations and a not guilty on the new law violation, and ask that they be scheduled for December the 13th.
State? Any objection to that date?
Your Honor, I did not hear him. I apologize.
December 13th.
No objection. Continuing this matter to December 13th.
All right. So December 13th
Emailed about your record, okay.
is the court date on all cases. They'll all track together.
Yes, Your Honor. Thank you, Your Honor.
Thank you.
If I could take one out of custody, Alicia Irby, Your Honor. This Irby should be number 22 on the docket.
I have it down as 23. I think there was something added. Case number 22, CF2875.
Yes, Your Honor. At this time, we are going to enter a denial on the VOP and ask that it be rescheduled for the next miscellaneous date.
All right, and that is December 14th.
Is this Miss Irby?
Yes.
Okay.
Yes, 22 CF 2875, December 14th. It'd be the next court date.
Yes, Your Honor.
All right, and obviously Miss Irby is out on bond, is that
Yes.
right?
Yes, Your Honor.
All right, thank you, ma'am. Stay in touch with your attorney.
Your Honor, next I've got is going to be Mr. Ladarius Jackson.
Okay.
I have it as docket 23, but I'm sure your docket is probably different.
Yes, it's 24 on my docket. It's case number 23 CF 1354.
I have Mr. Jackson, and let me make sure I've got, looks like I've written the wrong case number down on, no, I've got the right case number. If I can approach with the plea agreement, Your Honor.
Sure, thank you.
It's a modification, so no score sheet will be necessary.
All right, would you like to announce the terms?
Yes, Your Honor. Mr. Jackson will be entering an admission to the violation before the court. He was previously adjudicated guilty. We're going to modify and reinstate his probation. His probation termination date will be extended by 12 months. The next 12 months of supervision will be community control, followed by the balance of his supervision. $100 cost of prosecution, $150 public defender fee, complete in the original requirements. And I'm assuming probation is going to want his address, which we'll give after we are sentenced, Your Honor.
I do have one question. The
Yes, Your Honor.
case number at the top of the agreement matches 23 CF 1354, is that case number? But then down here, it's a 2021
Yes, Your Honor.
case number?
I recycle my plea agreements, and that's his old VOP case that we had. That's
Okay, so
my-
it should be the 2023 number, right?
Yes, Your Honor.
Okay, let me fix that, just so there's no confusion. And the underlying charges are,
Possession of controlled substance and possession of paraphernalia. Count 2 was the original pled out, this time served. He was on probation for count 1.
thank you. And, sir, if you'll just please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. And state your name.
Dennis Jackson.
And, sir, did you sign this agreement?
Yes, ma'am.
Did you sign it today?
No, ma'am.
Oh, okay, because it has a different date on it, I'm just making sure. Have you had an opportunity to discuss the allegations that you violated your probation with your lawyer?
Yes, ma'am.
Do you understand that you are giving up your right to have a contested hearing to make the state prove the allegations against you?
Yes, ma'am.
Is anybody forcing you or threatening you to enter a plea today?
No, ma'am.
Is anybody promising you anything except what's showing on the plea agreement
No, ma'am.
and announced by your lawyer?
No, ma'am.
Did your lawyer correctly announce the terms of the agreement?
Yes, ma'am.
Are you currently on any alcohol, drugs, or any medication or any other substance that affects your ability to understand what's going on?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what's happening?
No, ma'am.
Have you had enough time to talk to your lawyer?
Yes, ma'am.
Are you happy with his services?
Yes, ma'am.
Did you read the agreement?
Yes, ma'am.
And what day did you sign the agreement?
Yesterday, the 20th.
Okay, just verifying the date, and is that your signature on page 2?
Yes, ma'am.
Okay, thank you. Do you wish to enter an admission to the allegations that you violated your probation in case 23 CF 1354?
No, ma'am.
Do you wish
No,
to
you
enter
don't
an
want to
admission?
admit?
Oh, yes, ma'am.
You do want to it. How do you plead to the allegations that you violated your probation in 23 CF 1354?
Guilty.
You admit the violation.
I'm in violation.
You're admitting the violation?
Yes, ma'am.
Okay. Are you doing so freely and voluntarily?
Yes, ma'am.
I accept your admission. I do find it was freely and voluntarily entered. And is there a score sheet?
Because it's a modification, it's not necessary, Your Honor.
All right. And there's been a previous adjudication, so we are modifying and reinstating probation under the terms and conditions that were announced by Mr. Gates. And we also need an address, do we not, for the community control?
Yes, Your Honor, and I asked him that. His address is going to be 102 Burnett Avenue. I think it's in Fort Walton Beach, 32547.
All right. And sir, you'll need to, when you get out, does he need to call probation as soon as he gets out, or what does he need to do?
Yes, ma'am. We're providing a phone number for the CC officer.
Excellent. So call that number when you get out. You must be at the address that your attorney just gave. You're on community control the minute you get out of jail. If you leave that residence without permission, then that would be a violation. Do you understand?
That's right.
All right, so have I failed to cover any terms or conditions?
Mayor, just that report to probation by 8 o'clock Monday morning.
Yes. Unless, well, it's unlikely he'll get out before 1 o'clock today. So you need to be at probation 8 o'clock Monday morning. State, did I leave off anything?
No, Your Honor, thank you.
Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you. Thank you very much.
Your Honor, the next one I've got is going to be William Killingsworth.
All right, that is 23 CF 2156.
Yes, Your Honor. Mr. Killingsworth is making his way to the podium. It has been scheduled for a bond hearing.
Oh, yes, thank you. I have that in front of me. There's a motion for bond reduction filed on October 3rd, 2023.
Yes, Your Honor.
All right, and State, who's handling this one?
This is Noah Lasco on behalf of the state.
All right. Mr. Gates,
Yes, Your
whenever you're
Honor.
ready, go ahead.
Mr. Killingsworth and I had talked. At this time, he's going to forego making these statements this morning for the bond hearing, so it'll be straight to argument. Mr. Killingsworth has significant ties to the community. He's lived here, my bond motion specifically states 26 years. He's lived at the same address for a number of those years. He shares that address with his 88-year-old grandmother, who he helps take care of, provide support for, both monetary and physical support for her. He has little to no criminal history in this case, Your Honor. I'm just going over my notes to make sure I get it all. Obviously there's a potential in this case for a stand your ground self-defense issue. The $400,000 bond we feel is a bit excessive. We'd ask the court to consider reducing it down to something that we requested, which was $40,000. Mr. Killingsworth had made a couple purchases towards starting his own business, which was a lawn maintenance business. He does have several people in attendance this morning, including his girlfriend and his neighbors. They all are supporting him through all this. We'd ask the court to take that consideration on reducing the bond.
Defense or State?
Certainly not the defense, Your Honor.
Sorry about that, Mr. Lasco.
Yes, Your Honor. Well, Mr. Gates has said that this defendant doesn't have little to no criminal history. He does have one prior felony that was withheld. That was a DD, bat, or strangle. I would present to the court that although he doesn't have significant criminal history, he certainly has jumped in with both feet. I'm sure the court did review this record and knows that this defendant, after being rear-ended by the victim in this case, chose to shoot the victim. He shot the victim 3 times, once actually landed and injured the victim in the leg. Another bullet went through and shot the rearview mirror off a car that was driving by, Judge. This is obviously a very serious case. He presents a threat to the community. He presents a threat to our society if he is released. I don't believe that there are any reasonable restrictions that can be placed on him to preserve the safety of the community, and frankly, I don't think the bond as it currently states is enough, Judge. I would say that I've spoken with the victim, and the victim who was shot in the leg, as I previously said, he wanted to be here today. This bond motion was previously set for last week. He was going to be here last week. However, because of a work commitment, he could not be here this week. So he is strongly opposed to the defendant being assigned a lower bond, and that is the victim's position at this time, as is the position of the state, Judge.
And if I may respond, Your Honor, I would say there are resources available to the state if the state feels that there are no other alternatives to the safety of the community than to keep Mr. Killingsworth in jail. We haven't gotten any of those. We haven't seen any of those motions. The first appearance report indicates that he is to be on pretrial services along with surrendering any sort of firearms that were not seized. He intends to cooperate with all that. Just so the court's aware on the domestic violence strangulation, that was actually his older brother, who was a well-known convicted felon, Scott Moose, who has significant criminal history. And shortly after this incident, when they were allowed to have contact again, proceeded to attack my client and brandish a machete at him shortly after all this was completed. So, yeah, he does have a prior, but I would argue that it's insignificant considering the allegations in that charge. As far as this case is concerned, Your Honor, the record's clear here. This all started because of aggressive driving, not on behalf of Mr. Killingsworth, but on the alleged victim in this case. That the aggressive driving occurred over roughly a mile or so. Several times the victim came close enough to striking Mr. Killingsworth's vehicle that ultimately happened crossing Brooks Bridge, at which point he struck the back of Mr. Killingsworth's vehicle. At that point, instead of calming the situation down, the victim took it upon himself to exit his vehicle, throwing a cup at the vehicle, and then aggressively approaching the driver's side door of the vehicle. And unfortunately, in July of this year, the court's aware, legislature decided to remove the concealed weapons permit. So at this point, we don't know, Mr. Killingsworth didn't even know if this man was armed or not. He knew that he'd been aggressive. He knew that he struck the back of his vehicle. He knew that he threw a cup at his vehicle and now was approaching the driver's side door. Mr. Killingsworth does deny that he ever stepped out of the vehicle, and according to eyewitness accounts, he never stepped out of the vehicle. Allegedly leaned out of the vehicle, fired 3 rounds off in self-defense, and then proceeded to leave the scene and then put the firearm in some bushes next to a business where he knew would be recorded so law enforcement would see that he had just put the firearm away from him, so when he was taken into custody there were no issues with that. Clearly this is a situation where there's a lot more to it than just the charge itself. We'd ask the court to take that into consideration along with his little to no criminal history, strong ties to the community.
Your Honor, may I?
Of course.
Judge, I would also like to thank the defense for reminding me, this defendant did run away after firing those 3 bullets, and he stashed the gun in some bushes. So I would say that he's already run once. I would say that he's facing an offer of 25 years and has every reason to not want to remain in Okaloosa County, Judge. I would also say that throwing a cup at someone certainly doesn't constitute standing your ground and give you license to shoot 3 bullets blindly out your car at somebody. So for that reason, Judge, the state does believe that the current bond, if anything, is too low and should not be modified downward.
And just
last word, go ahead.
Yes, Your Honor. I would say the standard ground doesn't qualify and say, well, only if they're throwing a cup, you're not entitled to. No. Standard ground says if someone's acting aggressively, you have the right to defend yourself. At no point is there an allegation that Mr. Killingsworth did anything to act in aggression upon that. And in fact, everything he did, according to eyewitness reports, were in response to the aggressive behavior by the alleged victim.
So it sounds like that is ripe for a motion. I don't know if one has been filed.
Yes, Your Honor.
But I'm not going to litigate a stand your ground motion on a bond
Yes, Your Honor.
hearing. The bond is currently set, correct me if I'm wrong, at $250,000 cash or professional on the aggravated battery with a deadly weapon charge and $150 cash or professional on the charge of firing a weapon, discharging a firearm from a vehicle. Is that correct?
Yes, ma'am.
All right, with other terms and conditions. Both of those are second-degree felonies, and these are pretty serious charges,
Yes,
pretty
ma'am.
serious set of facts. I am not inclined to reduce the bond in
Yes, ma'am.
light of the seriousness of the set of facts that have been presented to me, or proffered rather, by the attorney. So with respect, your motion is denied. I'm sure you will be filing another motion, and then Judge Ketchel can hear that and evaluate it.
Mr. Killingsworth and I talked about that. Depending on what happens in discovery, we may approach the idea of another bond hearing at another date.
Thank you. Good luck to you. Thank you.
Thank you.
Thank you.
And just so Mr. Killingsworth's scheduled for December the 13th is the next court date.
Yes, that's right.
And the last one I have, Your Honor, is going to be Mr. Pasha Turner.
All right, that is 22 CF171. And after this case, we will probably take a break. It is 11:30. It's after 11:30, and some of us have been sitting here for 2.5 hours, so we'll take a quick break after you finish.
Yes, Your Honor, this is going to be my last one before
All
the
right.
court, so that works out well. If
All
I
right.
may approach with a plea here, Your Honor?
Yes, absolutely, thank you. Thank you so much.
As with Mr. Jackson, this is a modification. There'll be no score sheet filed in this case.
Okay. And would you like to announce the terms and conditions?
Yes, Your Honor. Mr. Turner will be admitting the violation before the court. He was previously adjudicated guilty. We're going to modify and reinstate his supervision. He'll be placed on 36 months of drug offender probation with a curfew of 7 p.m. to 7 a.m., which can be modified by parole and probation for work purposes, undergo a substance abuse evaluation within 30 days of his release, any recommended treatment within 60 days of his release, random urinalysis, complete original requirements, $100 cost of prosecution, and $150 public defender fee.
All right, and state did, well, it looks like you signed it, so those terms and conditions are accurate?
That's correct, Judge. Thank you.
All right. And sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down and state your name for me, please.
Pasha Ali Turner.
Thank you. So in case 22 CF 171, it's alleged that you violated your probation. Have you had an opportunity to talk to your lawyer about those allegations and any possible way to defend against them?
I talked to him, yeah.
Did you read the agreement?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Is this your signature on page 2?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am.
Are the terms of the agreement that your attorney stated, is that your understanding as
Yes,
well?
ma'am.
Do you agree to those terms?
Yes, ma'am.
Is anybody forcing you or threatening you to enter a plea?
No, ma'am.
Is anybody promising you anything other than the terms that were stated by your lawyer and that are set forth in the agreement?
No, ma'am.
Are you currently on any medication, drugs, alcohol, anything that affects your ability to understand what you're doing?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what you're doing?
No, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Do you wish to enter a plea admitting to the allegations that you violated your probation and have me impose sentence in accordance with your agreement today? You wish to admit to your violation?
Yes, ma'am.
All right. So as to the allegations that you violated your probation in 22 CF 171, how do you plead?
Guilty.
I accept your admission. I find it was freely and voluntarily entered. And we are going to modify and reinstate your probation in accordance with this agreement that you've signed. And there's a previous adjudication of guilt, it appears. So modification to 36 months drug offender probation with the curfew stated by Mr. Gates, which can be modified at the election of the probation office for work purposes, substance abuse evaluation, treatment, random UAs, complete all your original requirements, and you need to pay any outstanding costs or fines on the original charge, and then there will be additional fines and costs of $100 cost of prosecution and $150 public defender fee. I'm going to write on here and all other outstanding fines and court costs. Did I cover
No, Your Honor.
everything? Did I miss anything?
No, Your Honor.
All right. All right, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. You need to report. Is this the only thing holding you in jail?
Yes, ma'am.
All right, you'll get out today. I don't know if you'll get out in time to get to probation today. So drug offender probation, what does he need to do? Give you an address today or what?
You'll be staying at the same address as well. So that's fine, just knowing that your curfew will be will be set, so as soon as you release that curfew is imposed, 7 p.m. to 7 a.m., and then you just report to our office Monday morning at 8 a.m.
All right, so be there at 8 o'clock Monday morning at probation, and your curfew starts today. So if you're out after curfew, that would be a violation. Good luck to you, sir.
Your Honor, I don't have anything else before you. May I be excused?
Yes.
May I, Your Honor?
Yes, absolutely. Happy
Thank you,
to.
Your Honor.
Judge, may we approach, because we have a correction on that order, that
Yes.
case number was...
Of course. Come on in.
Thank you, Steve. Good to hear.
Look, Your Honor, I just prepared an amended order with the corrected case.
$306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy? Injured? Take a breath. Call Coy.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves,
Good morning, sir. I'm Judge Clark. Can you state your name?
Nicholas Gomez.
All right, thank you. And you're here on case 23 CF 11519. And you're here on allegations that you violated your probation. Sir, can you afford a lawyer?
Me? Yes.
Okay. Are you currently represented by an attorney?
No, ma'am. I was told by my PO it's just gonna be a reinstatement. Because I've already been seeing him ever since I've been out and everything.
All right. State?
If you'll give me just a second, Your Honor, I'm looking up this case. This is Mr. Olasco's case, and I think he thought that, he was not gonna be here today.
My PO called me this morning and told me I needed to be here, so I came.
Your Honor, this time it doesn't look like the state has an offer for Mr. Gomillion at this time. If we can have him come back on December the 14th, I think Mr. Lasco will have an offer for him.
Okay, I have it down that you don't have an attorney. You said you can afford an attorney, sir?
Yeah, he told me not to worry about nothing like that. My PO did. He said, don't worry about no attorney. He said, when you go in there, they're just going to reinstate you because you already came back and seeing me. He said I was already reinstated and stuff, so that's what I didn't think of nothing like that.
You have the right to have a lawyer represent you. If you can't afford a lawyer, I will be happy to appoint one for you. So the state's not aware of any such agreement. Let me advise you, you're being recorded. I'm encouraging you not to discuss any of the allegations.
Yes, ma'am.
Could be used against you in the case.
Yes, ma'am.
So, sir, we're going to set you on which date?
December 14th.
Oh, December 14th at 9 o'clock.
Okay.
That's your next court date.
Okay.
And I would encourage you to, if you're going to hire a private attorney, go ahead and do that.
I've already been talking to one. I just didn't. I was told not to bring there wasn't going to be no need to bring one today, so I didn't tap him to come up here or nothing.
Yes, Your Honor. Please DOP arraignment. Do you want to hold off on entering a plea at this time until he can speak?
Yes. Let's just continue. Well, is there any objection from the state?
No, Your Honor.
Okay. I'm going to continue your arraignment
Yes, ma'am.
and let you speak to an attorney and have that person present with
Yes,
you.
ma'am. Yes, ma'am.
Because today would be the day that you would either admit or deny the allegations. I'd like for you to have counsel present if you're
Yes.
talking to counsel. Okay?
All right.
All right, so December 14th at 9. Thank you.
Mr. Gill?
Good morning. Can you tell me your name?
Johnny Hill.
One more time, I'm sorry.
Johnny Hill.
Oh, okay, thank you. All right, sir, you're here on case number 18 CF 2511 and 21 CF 1038. There are allegations that you have violated your probation. You have the right to have a lawyer represent you. If you can't afford a lawyer, I'll appoint one for you. Can you afford a lawyer?
No, ma'am.
Would you like me to appoint one?
Yes.
All right, there's an application you'll have to fill out to make sure that you qualify. We have that application here. So you do need to fill that out, answer every question, fill in every blank, circle every yes or no, and you'll need to turn that in before you leave the building to the clerk of court. I'm going to go ahead and appoint the public defender's office to represent you on a provisional basis pending the clerk's review of your application.
Your Honor, just, what is your last name, sir?
Hill.
Hill? Okay, you're going to be Travis Gates's client. I'm going to put his name on my card, okay? But it's the same phone number. And I'm going to put Vicky, who is our assistant, and you can call her and set an appointment, sir. Thank you. But as the court directed, please, before you leave, make sure that's fully complete and turned in with the clerk on the first floor, okay? Thank you, ma'am.
Mr. Medina, do you wish for me to read the allegations?
Oh, no, you're all right. It's a VOP?
It is.
Your Honor, he can go ahead and deny the VOP, and we'll put him on for December 14th, if that's okay.
Yes.
Okay. Some didn't need to be rude. 12, 14, 23, 9 a.m. is your next court date, okay? Call Vicky and set an appointment with Travis, okay?
All right.
Fill that in for you.
Good luck to you, sir. Please fill that out and turn it in before you leave today, okay?
Yes, ma'am.
Thank you.
First floor, first floor.
Chartrand.
Yes, sir.
Chartrand, girl.
Thank you.
Is it real Chartrand?
All right. Good morning, I'm Judge Clark. I'm covering for Judge Ketchel today. And can you tell me your name, sir?
Israel Chartrand.
All right, you're here on 22 CF 2721 and 22 CF 3012. And sir, it appears you filed a motion for early termination of probation. Is that correct?
Yes, ma'am. I would like to clarify for the court, this is just for the CC portion, so I can start the regular probation that follows the CC.
All right, thank you. And what is the state's position?
Your Honor, the state's position is that it does oppose him being released early from community control. He has barely begun a 1 year of community control, which was ordered by the court. Your Honor, he also has not begun the batterers intervention program, which was ordered when he was originally placed on probation. It still has not been done. Just for a procedural history, recently, like within the last month or two, he did have a violation which the state and the public defender's office and Mr. Chartrand resolved. The community control was an offer, or just this modification that he recently just got was a downward departure. It was at the victim's request. There were some extenuating circumstances that the state did give him another downward departure, so the state is not agreeing to release him early from community control. I spoke with Officer Shelton, who is his supervising officer. Officer Shelton states that he is, I guess, convinced that he will not be able to work on community control, and she is stating that he can work, but he may not work outside of the county, that she does not allow that. So he, I guess, was upset that he was not allowed to work outside of Okaloosa County, and she says it's standard for people on community control, and the state does agree with the probation office's usual procedure about that, Your Honor. So again, the state and the department are opposing his early release from community control.
Would you like to respond?
Yes, ma'am, I would. I was placed on probation around April the 12th, 2023. I was on probation for about 4 days, and then an alleged violation happened due to my mental condition. I stayed incarcerated for a little over 6 months. The resolvement of the violation was turned out that I did not violate my probation, and all the time that I was in the county jail was credited to my CC term of probation. Currently, right now, did 7 months and 9 days on CC. All my fines and obligations are paid for. The special stipulations that I did for the CC that they added for the supposedly reinstatement, but it wasn't. It was just a continuance of probation. I had to attend an evaluation of my mental condition, which I did. I'm currently being treated for my mental disorder. I'm currently on my medicine. I'm currently transferring all the records from Lakeview to the Shalimar office.
And like I said, I discussed this with Ms. Shelton, and Ms. Shelton is under the impression that I violated probation, and she didn't agree with me being out. I had a very good job opportunity that was on the borderline of in Navarre. And she said, that's past the county line, and I was denied that. I said, are you serious? I didn't get in a big debate with her. Later on Halloween night, I was approached by 2 officers under the orders of Ms. Shelton. They advised me at my house to take down Halloween decorations and do not pass out candy, and they allocated me as sex offender. I am asking this court to please take me off CC so the extenuance of CC will not be as harsh on me and allow me to move around more freely. I got a permanent residence. I take urinalysis tests every week. I've not had no infractions with nothing. I did have to do a medication renewal, which I went back to Baptist Hospital and I got back on the same medications that I was on. Ms. Sharpless mentioned about the batter's intervention. I filled out the intake form is here. I'm waiting on my first paycheck so I can start that. But clearly, if I have 30 more months of regular probation, I can handle the batter's intervention with no problem. But as for this point, as for the CC, I'm well over my half. The fines are paid. I've met all the special conditions, but then again, like Ms. Sharpless said, the batter's intervention, I'm waiting on my first check, and I'll start that. But I have 30 months to complete it. So I don't really see why this court shouldn't grant my motion. That's really all I have to say.
Thank you, sir. So I reviewed the case to prepare for this hearing, and it appears that your original plea, which was entered on April the 12th, 2023, was a downward departure, correct? You scored prison?
I believe so.
You scored 22 months prison, if I'm not mistaken.
I believe so.
The judge who took your plea, which was Judge Ketchel.
Yes, ma'am.
Agreed with the state's offer. It was a plea bargain. So he departed from the sentencing guidelines. Rather than send you to prison, he put you on community control in accordance with the state's agreement. So since this was already a downward departure, then I'm not inclined to terminate community control early under those circumstances. So with respect, I'm denying the motion for early termination of community control. Good luck to you, sir.
Thank you.
Your Honor, Steve Medina with Chandra Beard. She's docket 27, 22 CF 1941. This was I believe it's misdemeanor VOP, and the state does not have an offer, I learned yesterday, because the state anticipates that there might be a new law charge or charges pertaining to a probation-initiated search of her residence. At this point in time, Ms. Beard is going to deny the violation. We probably need to be put on December 14, but I'm asking and pleading with the state if there are going to be any additional charges, that it be done as soon as possible so that maybe we can get her a plea day before December 14th, maybe do some sort of a global plea for probation or something like that, because she does have you have 2 children, is that right? So there's some exigencies. Added a couple vowels there, but if we can get that resolved globally, I'm sure she would like to do that.
All right. So hopefully the state will be able to make an offer or make a decision about whether there's a new charge coming, and if so.
Yes, Judge, I was looking for a warrant yesterday. If I find out that there's a warrant coming for an additional charge, I will let Mr. Medina know as soon as I know.
And then we may be able to get her on a plea day before December 14th, I hope. So we'll do our best. Thank you.
Sure. So December 14th at 9 o'clock.
Thank you. Thank you, Your Honor.
Yeah, they're entering a denial today.
Thank you.
Thank you. All right.
Next is probably Selena Boyd, Your Honor. Selena Boyd, Your Honors, with Steve Medina, docket 2821 CF 557. Ms. Boyd has 3 new law cases, and at this time, she's going to deny the VOP. Basically, for a control date on the VOP, we probably need to put it on December 14th. I do believe that she has a plea day, might be December 14th anyway, on some new law case or cases, so December 14th with the denial for purposes of today, Your Honor. And I just also advised the state and the court, she's authorized me to work on a Phoenix house and Keaton evaluation, so we may be looking at alternatives in the near future.
All right, that's
Okay.
great. All
Thank
right.
you. All right.
Thank you. So a denial is entered, and the case is set for December 14th.
Thank you.
Will be all the cases, this
Yes.
one and any new law cases.
Okay, thank you, Your Honor.
Thank you.
And we've got this before the court is Caitlin Burnett. Ms. Burnett is docket 3422 CF 2281. We have a violation of probation agreement, and I will approach with the agreement. We don't need a score sheet because it is a modification, Your Honor. Okay. I'm just pulling it up on my phone because I have a copy here if I can. May I approach, Judge?
Of course.
Thank you.
Thank you. Thank you so much.
Thank you. And I'm going to provide a copy of probation. I know they were working hard here and want to not me throw curveballs. There was a small change to the agreement which they can write down. It's, we're adding some cost of transportation to the way it's written. Your Honor, there was also I'll announce the terms, but as part of the understanding with the state, there was no objection to entry of a Department of Motor Vehicles related business purposes order that basically expresses that the court has no objection to DMV pursuant to their regulations, giving her business purposes only if she qualifies. May I approach, Your Honor? Sorry to throw balls here.
Wait just a second on this one. I'm just making sure, because I don't want there to be a misunderstanding. I can't order the DMV to give a business purposes only.
That's correct, Your Honor. It's the intent is that the courts, basically as part of this deal, she's going to be adjudicated guilty on count 2, which was a misdemeanor, possession of marijuana, I think. And that's going to impose a driver's license suspension. So the intent of the agreement is that DMV, pursuant to its regulations, will do whatever its regulations say, but the court's not standing in the way if she does qualify to get at business purposes only. That's the intent. And we've used this form before, Your Honor.
And Your Honor, yes, it's the defense's hope that that order stating that the circuit court does not object to her having a hardship license if she's eligible according to DMV requirements will assist in getting it. It's absolutely not an order from the court. It's just stating that the court doesn't object if she's otherwise eligible.
Well, it doesn't state the court doesn't object. It states the Department of Motor Vehicles is hereby directed to issue a license, and then there's some more language, if the defendant is otherwise qualified. I just don't want it to be read like I'm directing DMV to enter.
Your Honor, we've always placed a lot of emphasis on that if clause, and we can make it clear if we need to, Your Honor. I don't think it's going to be a problem.
It does need to be clear that it's the court does not object.
Yeah, I'm going to have to modify.
No objection on the minute sheet.
Yes, I have no objection, assuming we go ahead and enter the plea. But I want to make sure that this order is clarified to say that the court has no objection to the Department of Motor Vehicles issuing the business purposes only license if the defendant qualifies, but I am not directing them to do so.
Understood, Your Honor. Thank you for that clarification.
Ma'am, I cannot guarantee that they will give you a business purposes only license. That's between you and the
Correct.
Department of Motor Vehicles. I can't tell them to do it.
Correct. He let me know that it was up to the DMV.
Good, I just want to make sure, so I'm just going to change this order really quickly just to clarify.
Thank you, Your Honor.
Sure. Okay, so I changed it to state, ordered in a judge that the court has no objection to the Department of Motor Vehicles issuing a license for driving privilege restricted to business or employment purposes only as defined by Florida Statute 322-271 if the defendant is otherwise qualified for a license. So,
Thank you, Your Honor.
Sure. Just give me 1 second to finish this order. All right. So regarding the plea agreement.
Yes, shall I address the announce, Your Honor? I'm sorry, I was doing things cattywampus here. So the defendant under this violation of probation agreement is admitting the violation. There'll be a withhold of adjudication on the felony count, which was count 1, felony VOP, reinstate and modify supervision to make the next 12 months of her supervision on community control. She will complete original terms and conditions, and that includes the original term of supervision is unchanged. So she has a more lengthy period of supervision that will continue beyond the 12 months community control. There's an adjudication of guilt and revoke and terminate for time served only as to count 2, which was the misdemeanor VOP, Your Honor, with underlying possession of marijuana misdemeanor. $100 VOP fee, $150 public defender fees, $89.45 in reimbursement to Okaloosa County Sheriff's Office for transport. And I believe those are the conditions, Your Honor.
All right, and just to make sure, ma'am, do you understand that if you're adjudicated guilty on count 2, that your driver's license will be suspended?
Yes, Your Honor.
And what would be the period of time? Is it 6 months or a year? I cannot remember.
I think the agreement says whatever is by statute applicable. It typically might be 6 months, but I never want to say for sure because sometimes DMV regulations have minutia that I'm not familiar with.
I can't remember off the top of my head. I wrote on here, driver's license suspended per statute.
Thank you, Your Honor.
Sure. So
will the DMV have that answer for me on how long my license
Yes.
is going to be suspended?
Yes, ma'am. So, ma'am, if you'll just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down and just state your name for me.
Caitlin Burnett.
Thank you. So it's alleged that you have violated your probation in case 22 CF 2281. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes.
And do you understand that you are giving up your right to have a contested hearing and make the state prove the allegations?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, medicine, anything that affects your ability to understand what's going on?
No, Your Honor.
Are you suffering from any mental illness that affects your ability to understand what's happening?
No, Your Honor.
Is anybody forcing you or threatening you to enter a plea today?
No, Your Honor.
Has anybody promised you anything other than what's showing on the agreement and what your attorney announced?
No, Your Honor.
Did you read the agreement?
I did.
Okay, looks like the agreement is not signed, so I'm going to ask the...
Oh, I'm so sorry, Your
No
Honor.
problem. I'm going to ask if the defendant could please sign. No problem with that. Just get her to sign it. Here we go.
And we all needed to sign it. I just got ahead of myself.
No problem.
I don't think you did, but you were good with it. The state wrote the original notation about the cost of transportation, so I know Miss...
I think Ms. Sharpless did sign it. I think I saw some red ink on page 2.
And so I thought
Oh, okay.
signed it in red today.
Oh, okay. Very nice. Yeah, the VOP, Your Honor, agreement is a little different than the regular plea form, so let's see.
We're working with the pen we have today, Judge.
Do you need an extra pen?
No, ma'am.
Okay, I brought some extras.
Thank you, Your Honor.
Sure. All right, thank you so much. So, ma'am, did you read this agreement?
I did, Your Honor.
All right, and I just watched you, it looked like you signed something up there at the podium. Did you sign this agreement?
Yes, I signed that agreement.
All right, and is that your signature in blue on page 2?
Yes, ma'am.
All right, thank you. Is there anything about the agreement or what your attorney stated that you don't understand?
No, ma'am.
Are you happy with your lawyer's services? I need you to answer out loud.
Yes, ma'am.
All right, thank you. Did he answer all of your questions?
Yes, Your Honor.
Are you admitting to violating your probation in 22 CF 2281?
Yes, Your Honor.
Thank you. I accept your admission. I find it was freely and voluntarily entered, and I am going to reinstate and modify your supervision as to count 1. That is the felony count. The vehicle theft, that's a 3rd-degree felony. And the next 12 months will be on community control. You'll still have to complete your original terms and conditions and pay any outstanding fines and court costs from that original charge and the terms and conditions that were announced by your attorney. As to count 2, we are, revoking and terminating your supervision for time served on count 2, and there is an adjudication of guilt. That is on the misdemeanor charge of possession of marijuana, not more than 20 grams. And that does come with a driver's license suspension, as we discussed, as per statute. There will be additional fines and court costs, $100 VOP fee and $150 total cost of defense fee. And also there's $89.45 in reimbursement to the Okaloosa County Sheriff's Office for transport. Did I leave out any terms and conditions?
No, ma'am, Your Honor, but she will in general have to complete the original terms and conditions.
Absolutely. And ma'am, well, let me ask probation, do you have an address for her, or do you need her to give you one?
Ms. Burnett, are you still going to be residing in Santa Rosa County?
No.
Where are you going to be residing?
I will be back at my mom's at 100 Driftwood. 100 Driftwood Avenue, Southwest.
If she could announce that into the microphone so that we can get it down.
Is that Fort Walton Beach?
Yeah, it's Fort Walton.
And what's the zip there?
Do you know the zip code, ma'am?
32548.
What's your mother's name, ma'am?
You're going to go there right after you get out today?
Yes.
Okay, so you're on community control immediately when you get out, so you must remain at that residence.
Okay.
If you leave the residence without permission, that would be a violation.
Okay.
So you need to call, and probation, are y'all going to give her somebody to call when she gets out today? Or?
Yes, Your Honor.
Okay, great. And then, ma'am, you'll need to report to probation at 8 o'clock Monday. Is that right?
Yes, Your Honor.
Okay, great.
13 Kelly Avenue, Fort Walton Beach.
All right, and I'm entering this order. I've changed the title of the order to Order of No Objection to BPODL.
Thank you, Your Honor.
Sure, I'm just expressing that the court has no objection to the business purposes license if the defendant qualifies, that's up to the Department of Motor Vehicles and you to work out.
Thank you, Your Honor.
Thank you.
Good luck.
Good luck to you, ma'am. You have 30 days to appeal.
Probably, did you get to get printed because of the marijuana adjudication?
No, I believe so.
All right.
Oh, credit for time served on the count two.
Yes.
That's the misdemeanor possession of marijuana, and probation is revoked and terminated on
Yes,
that
Your Honor.
adjudication appeal. So, ma'am, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer to appeal, I will appoint one for you. Good luck to you.
Thank you, Your Honor. Your Honor, the next client doesn't technically have the public defender. This is, but I have him on another case. This
I
is,
hope that the next 12 months is community controlled and followed by the balance on regular probation.
that is correct.
It's just, it's not on here that way, but that's the way I got it on the minute sheet. I figured that it was on there.
Do we need to get her out? That was the intent.
Oh, maybe so, just if she's not too far gone. I just want to
Can
make
we
sure
get
that
Miss, you might need to step back.
Ms. Burnett, if I can, real quick, please. Right this way, so you-
balance. Okay, so I'm just going to write it on this plea agreement. This is on Miss Caitlin Burnett, 22 CF 2281, that just left the room. We're going to bring her back.
Yes, Your Honor, I said it, I know it was on the record, but we probably,
Ms. Burnett,
yeah,
for a minute.
I should have written it out. in more
It is-
detail. That was the intent of complete original.
Please get her.
Hey, Ms. Burnett, I just want to get it on the record to make absolutely sure, the next 12 months, this is as to count one only, is community control, and then the balance of your original term is on regular probation. Did I state that correctly, attorneys?
That's correct, Your
Yes,
Honor.
ma'am.
Okay, is that your understanding, ma'am?
Yes,
Okay.
with count one, or count two, since that was terminated, was that the drug offender probation that I was on?
No, ma'am. When you, Your Honor, just to clarify, she was under drug offender probation. What I explained to her, because it's complete original terms and conditions, is that basically, when she gets done with community control, she'll be under drug offender probation conditions.
Okay.
Because that was part of the original terms and conditions.
Okay.
Because it's complete original terms and conditions.
That's correct.
And that included drug offender conditions.
Yeah, yes, Your Honor. I think her original termination date was sometime in 2025 or 2026.
Only if that's announced in court.
Okay.
If not, and it's just announced followed by probation, it would default to standard probation after that. So it has to be announced.
The intent was for her to return, the intent was for her to turn to drug offender probation for the remainder of her probation. I believe her termination date was sometime in 2026. So that's why the state did not extend her probation. It was the intent for the next 12 months for her to be on house arrest, community control, and then revert back to drug offender probation for the remainder.
Okay, Your Honor, I need to pull the agreement out, I mean, the original file. Because she's explained to me that, Judge, I was just going based on what, a question she asked. I didn't actually go back and look, but she's reminding me. I'm incorrect that it was the principle is that she'll complete the original terms and conditions, but the original deal that she entered in January 10 of 2023 that's being disposed of today was 6 months drug offender probation followed by 2-year standard probation. So by the time she's done with the 1-year CC, she'll be just on standard probation.
Is that correct?
I'm sorry, Judge, if you'll let me.
Yeah.
If that was what was originally ordered, Your Honor, then yes, that's correct, but give me just a second. I'm sorry.
And there was a modification on a prior violation of probation, and she was extended another 6 months on drug offender probation.
Okay.
From the original.
Okay.
It'll still be taken care of
That will still be that'll still be in the 12-month period?
Yes.
Because that was an extension, an administrative order without public defender or a court
So,
official.
She
yes.
accepted the plea
Right.
without counsel being appointed.
So in June, Your Honor, she was extended an additional 6 months on drug offender probation, followed by 2 years of standard probation. So, yes, Judge, she'll do 12 months on community control, and then she'll revert to regular probation for the remainder.
Okay, so let me just write this on.
Good question. I'm sorry, Judge.
No, I'm
She
glad
she
you
asked
asked
great
that.
questions, and I gave her an answer that was intended to address it, but she actually had better information, so.
So what I did, unfortunately, I had to do some scratching out on the plea agreement. What I'd like to do is send it back, have Ms. Burnett initial where I did. Oh, yes, of course. You can see what I wrote on there. I wrote balance on regular probation, I believe. I scratched it out a
So the
time.
judge gave her initials with balance on regular probation, so that's good. Does probation want to see that?
Make sure that that's accurate. And Ms. Sharpless, if you'll take a look and make sure that the language I wrote on there captures the intent of
Yes, sure.
both parties? Okay.
Your Honor, just to confirm she saw it, she'll initial by Your Honor's initials.
All right, thank you. So ma'am, just to make absolutely sure, you're initialing right next to my initials, so you're going to do 12 months on the next 12 months on community control. That will take care of your current drug offender probation. And then after you finish your 12 months on community control, the balance of your term of probation will be on regular probation.
Okay, during those 12 months, would I need to follow drug offender probation as well?
Well, Your Honor, community control is heightened, it's the most heightened supervision. It, for instance, in lieu of a curfew, which was going to be a 7 to 7 curfew, it's actually a 24-hour curfew except for approved work and medical type approved. So it's more difficult. With respect, the other main requirement are heightened UAs, and I think that it is the normal practice of, I don't know if it would be Officer Keene, but whoever it is, they're very strict on that. So it is community control, whatever the community control officer says, that is the next 12 months.
Basically, you're not going to be able to leave your approved residence without permission.
Understand.
Yeah. So let me ask this. Would Ms. Burnett score prison if she were to be adjudicated on count 1?
No, Your Honor.
Okay.
Now, if she were to pick up a new violation,
Basically, that's what I'm asking.
then it's certainly possible, but her score, according to the state score sheet, was 35.2 points. So we do not know what would happen to her were she to violate. She could go to prison, but if she didn't pick up a new law, then she might not score prison.
So ma'am, you're getting very close to scoring prison if you're not there already and you violate again. I say that to encourage you to take this very, very seriously. Community control is difficult. You cannot leave your home unless you're following the rules and have permission. If you do violate, you could be facing prison. I just want to make sure you understand that and take this very, very seriously. So,
And she's also lucky that she's not becoming a convicted felon, which was a big
that
break.
is quite generous of the state.
Yes.
Especially, I heard there's a prior violation, so that is a very generous offer by the state.
Thank you, Your Honor.
Sure. So good luck to you, ma'am.
Thank you.
Your Honor, next is Mr. Dethridge Narong Deathridge. He does not currently have the public defender in 22 CF 959. I would ask for the public defender to be appointed. I'm sorry, I don't have the docket number.
Number 14.
How do you pronounce your last name?
Deathridge.
Okay.
All right. And sir, if you'll just state your name for me.
Narong Deathridge.
Thank you, sir. So,
He already has the public defender in a new law case, 23 CF 2154, that is currently set for December 13th, 2023. So I'm asking that the public defender be appointed without an additional application or anything in 22 CF 959, and that this be a denial on the VOP, continue to run concurrent with the December 13th. See if we can get his cases resolved globally at that time.
I thought it was December 11th that they had said that.
It's December 11th for out of custody, but if you're in custody, which seems likely, then you will be December 13th.
sir, you've been, well, it's been alleged that you violated your probation in 22 CF 959. Can you afford a lawyer?
No.
Would you like me to appoint one?
Yes.
I'm appointing the Office of the Public Defender in 22 CF 959, and Mr. Medina has already entered a denial on your behalf to the allegations of violation of probation. And I'm guessing he already filled out an application for the...
I don't know where that is, Your Honor, but if he needs one, we'll make sure that he gets it filled out. That's part of the obligations of the Public Defender's Office to coordinate with inmates on those kind of things.
Excellent.
Is there no way that we can resolve this today?
I'm not aware of a global offer today. The state may have one. Does the state have any information that would give him a right, ability to do a global offer today?
Not today. So when's he set?
I wouldn't be able to get no kind of signature bond or anything like that.
No.
3 CF 2154, and I've just, I was attempting to put this case on
Ma'am?
as well, if that's what Mr. Medina wants.
We're just talking about his court date, December 13th.
Yes, ma'am. Your Honor, I think it's most efficient to run it all that day, and we may be able to work something global out.
Absolutely. So this VOP case will track with the new law case, which is set for December the 13th with Judge Ketchel. And that's at 9 o'clock, I believe.
Yes.
Okay, great. Thank you.
Thank you.
Thank you. Good luck to you, sir.
Your Honor, next is Dionate N. Bradby, docket number 29, 18 CF 1025, 18 CF 1646, and 21 CF 2615. Essentially, we were here on a status, but before the court date, we received a court-ordered, state-requested second insanity-related evaluation that disagreed with the first evaluation. So I have filed a motion for a third appointment of an additional evaluator, and we can. If the court would take that under consideration, I don't know if there's an objection by the state, and I would just be submitting an order for the court's approval at a future time.
So are we here on the motion today? Or
I did not file a notice of hearing. We courtesy copied it to the state, thinking that it might come up. I did not realize that Judge Ketchel wasn't going to be here, Your Honor, so we can either re-notice it, or, actually notice it, but we did provide it informally. I don't know, Mr. Sharpless has an objection.
Your motion for a third evaluation, is that what you're...
Yes, ma'am. That's what the court is asking about.
Your Honor, the state doesn't object to that.
Okay, no objection.
And I'll submit a proposed order, and then the state can review it, and then it can go to the court.
Okay, what I will do is, since it wasn't actually noticed for today, I'd rather Judge Ketchel look at it. I can pass the motion to him and let him know that the state has no objection.
Could the court just take it under advisement without granting it? Or however, do we need to put it on a new court date? We've got to get a new court date anyway, and then it, in essence, can be stipulated without having to bring it up. So we're probably needing to be on December 13th for all those cases, Your Honor.
Okay, let's put it on that date. what I will do with the motion to order additional examination is if you two could submit an order, and I'm going to let Judge Ketchel address that motion. I don't
Yes,
know
ma'am.
what his thoughts would be.
That's fine, Your Honor.
I did see the motion filed when I was reviewing the case last
May
night.
I let Mr. Bradby know one thing, Your Honor? Just, thank you, Your Honor.
Sure, so what I'm doing is making a note for Judge Ketchel on the motion to order additional examination.
Yes, Your Honor.
That the state has no objection and the attorneys can submit an order to him, and then it would be up to his discretion if he wishes to.
Yes, Your
sign
Honor,
it.
thank you.
And he can appoint the expert if he grants it.
Thank you, Your Honor.
All right.
Your Honor, next is docket 30, Steve Medina with David Branch, 22 CF 2053. Your Honor, at this time, on behalf of Mr. Branch, I would like to enter a denial on the VOP. It is my intention to have this set for a VOP evidentiary hearing. I think the way the court's normal practice is that would have to be determined the date by the court's judicial assistant. So my office will be coordinating with Ms. Sharpless's office to schedule that as soon as possible, a VOP evidentiary hearing. I do want to state on behalf of Mr. Branch that this appears to be technical violations only, and that there were financial issues, so certainly willfulness with relation to his financial issues will be part of the situation. I know he's disappointed. I don't think it's in his best interest to address the court today.
I do want to, I'm sorry about that.
That's why I was putting that on the record, is I don't suggest that he address the court. I think that it would be better to let the lawyer do the talking today, but he's told me he wanted to speak. But I'm just putting it on the record that's against my recommendation, and that I think it should just be set for a VOP evidentiary, because we're not going to get it resolved today. I've discussed it with Ms. Sharpless, and she's made a lengthy prison offer, which he does not wish to accept, and she's not willing to do a get out of jail, suspended sentence type deal today.
Okay, just 1 second, sir, if you'll just bear with me.
Yes, ma'am.
Yeah. And
So today's just an arraignment.
Right, Your Honor, so I think I already entered a denial, and I would say for control purposes that we should put it on December 14th, and meanwhile, we will work on scheduling a VOP evidentiary hearing, but for control purposes, Ms. Sharpless makes a good suggestion that we go ahead and put it on 12/14. Because it's always possible something can work out even if we're waiting on a VOP evidentiary hearing.
Okay,
The financial issues included, for instance, he couldn't even afford the interstate compact transfer. He now has what he represents as good housing in Milton as well as a job. So it's his score is high because of some priors. Maybe not, there are a couple of alleged inaccuracies on his prior record that I've had previously raised and re-raised a day or two ago with the state. But it's still a high score even if we take out 30 or 40 prior record points.
so, sir, before you say anything, I need to tell you a few things.
Yes, ma'am.
First of all, you're being recorded.
Yes, ma'am.
Anything you say
Yes, ma'am.
could be used against you. The prosecutor is sitting right there listening, and you're being recorded. So I'm encouraging you to think very strongly and perhaps consult with your attorney before you say anything about the allegations.
Yes, ma'am.
Second, I need to tell you what the allegations are because today is an arraignment.
Yes,
correct?
ma'am.
So Judge Ketchel issued a warrant for violation of probation allegations and he did set that at no bond.
Yes, ma'am.
I'm just covering for Judge Ketchel today.
Yes, ma'am.
He is your judge who's assigned. He signed the warrant that has these allegations. And I'm just giving you information. I'm not expecting you to respond in any way. Failure to report in April 2023, failure to report in May 2023, failure to report in June 2023, failure to report in July 2023, and absconding, let's see, that was, looks like it's alleged that the officer had some conversations on July 8th and is alleging that you absconded on probation. And then the next three allegations, well, the next two have to do with failure to pay court costs and costs of supervision. And then the last allegation, number 8, is failing to undergo a drug or alcohol evaluation. And you were supposed to allegedly do that within 30 days of your being placed on probation, and that didn't occur allegedly. So those are the allegations in the warrant that you violated your probation.
Your Honor, may I say one other thing?
Yes.
I didn't want to interrupt. I just wanted the court to be aware that I would also, because he had previously had a evaluation by a licensed psychologist, I would be also getting a mitigation evaluation done because I think he might be amenable to treatment for the previous diagnosis was chronic PTSD and major depressive disorder, recurrent, severe. And so I just wanted the court to take that into account. Again, I hope he doesn't waive his Fifth Amendment privilege and testify today, but we're going to be doing everything we can to document that he's got some mental illness and PTSD that's amenable to treatment and that might help in a resolution as well.
So I'm not sure what you're wanting to say, but I don't believe the state is prepared to go forward with a contested hearing today. Sir, are you requesting a contested hearing on those allegations?
No, I really would just like to speak to the facts of the case, and I have a misunderstanding about what is really occurring right now.
Okay, I don't think I'm going to be able to resolve the case today, so I'm not sure how helpful those statements would be.
I don't think they'd be harmful.
I will defer to your attorney on that one.
I do not think it's a good idea because many times, and no disrespect to my very smart clients, but sometimes they think things aren't harmful and then in hindsight they wish they hadn't said something. So I'd rather he basically, we can prepare testimony at the appropriate time for a VOP evidentiary hearing and or a sentencing hearing. I don't think it's best for him to speak off the cuff when I don't know what he's going to be saying.
So, sir, do you need some time to talk to your lawyer, or do you want me to set this for another court date?
No, I don't need any time to speak with him.
Okay. I'm not quite sure what...
I'm just trying to speak to the court, that's all.
If you're about to admit the violation of probation, then that's something you probably need to set for another day.
Negative. No, that's not what I'm going to say.
And your attorney has advised you not to make any statements, but if that's what you're wanting to do.
Mm-hmm.
You might want to place him under oath. I don't know, Your Honor.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
And state your name, please.
David Branch.
All right, thank you, sir. Now, let me make sure you understand. We're not going to be able to resolve your case today.
Yes, ma'am.
There's not anything I can think of right now that you would say that would change the current situation.
Mm-hmm.
You will need to appear at another court date with Judge Ketchel.
Mm-hmm.
How you wish to proceed with the case will be up to you and your attorney, what y'all decide to do. But I just want you to understand, before you say anything, I can't resolve the case today.
Yes, ma'am.
I'm not changing Judge Ketchell's bond
Yes, ma'am.
today.
Yes, ma'am.
So I'm not sure what you're,
It's a question more
Okay.
than anything else.
I'm not sure I can answer it.
Last year, when I appeared before this court, was for possession or found by convicted felon, which was reduced to the possession of a concealed weapon. I caught that charge during the commission of attempted suicide. My wife just died. I tried to kill myself. I shouldn't have did what I did. I understand all that. But I'm here on a technical violation, and what I understand is I'm on 2 years probation. Ain't that what I'm supposed to get if I violate the 2 years? I don't know how this is going. Like, it doesn't make sense to me. You know, from what I understand, I haven't been in trouble since 2010. I haven't been in prison since 2010. I haven't had any substantial cases, you know, since coming home from prison. I went to prison when I was 16 years old. I'm 96. The points that they're looking at right there, that's got it so high, occurred in 1996. I just don't know why, you know, I'm on 2 years paper, why we just can't resolve, or what this, you know, 7 years. I don't understand what's going on. I'm just confused about it.
For the record, Your Honor, may I?
Yes, go
He's actually raising a good point, is that because he pled out to a third-degree felony, in addition to the fact that I pointed out there may be a couple of significant questions on the prior record that would affect the sentence computation, the maximum sentence in years probably should be 5 years, not 6.05 years, but I know he's not wanting to plea out to 5 years prison today, but I just wanted to put that on the record. There may be a couple of things on the score sheet that are going to change. Thank you.
Sure. So, sounds like the attorneys need to get together. Perhaps the state and the defense can work out whatever those disagreements are or issues. I'm not sure. So all I can do is set you another court date.
Thank you, ma'am.
Sure.
Thank
Are we
you.
setting an evidentiary hearing?
No, Your Honor, what it'll be is, yes, it'll be to be determined. I'm asking for a VOP evidentiary. What parties will coordinate with the judicial assistant of Judge Ketchell. Meanwhile, we'll have a control date of VOP of 12/14/23. It's possible we'll work matters out without an evidentiary hearing, and that would be a good control date for that. Thank you.
Thank you.
And I'll be getting a mitigation evaluation initiated in the meantime. Thank you.
Thank you.
Tyler Bunch? Your Honor, may I, just 1 second?
Sure.
Your Honor, Steve Medina with Tyler Bunch in docket 3323 CF 807. That is VOP. I would ask to enter a denial on the VOP. He's set for pre-trial in a new law case, 23 CF 2241 on December 13th. I'd like to continue the VOP that same day, December 13th. By then, hopefully, we'll be getting a global offer from the state. We do not have one that takes into account the new law charge and revised score sheet and so forth and so on.
All right, and are you already appointed on this case?
Yes, Your Honor, I'm appointed in both cases.
All right, wonderful, thank you. So, sir, it's alleged you violated your probation, and Mr. Medina has entered a denial on your behalf. We're scheduling this current case, along with your new law case, for December the 13th? Yes, ma'am. All right, that's your next court date, sir. Good luck to you.
Yeah.
Thank you. Your Honor, next is Mr. Michael Bryant. And Mr. Bryant was 31 on the docket. And we have an agreement that we've been over that he is signing. We revised the first page. I went over the revisions. I think the state might have ma'am, did you have the original? You may have, you already, you gave it back to me, I'm sorry. So that's a copy for you. This is the original signed by the state, it's the same language, okay? That's where you sign. So we've been over the agreement, Your Honor, it just had to get signed. Yeah. Your Honor, do you mind if I let probation make a photocopy with their phone, because it might save them some labor? Give me a second, man. Yeah, I think this one's neater on the first page, so we'll go in it. All right, that's your first page. Yes, okay. Your Honor, this is going to be a modification with respect to the sole felony count that's going to continue in the case, so we do not need a score sheet. May I approach?
Yes.
Thank you.
Thank you very much.
Your Honor, under the terms of the plea and sentence agreement that's been signed by all parties, Mr. Michael Gregory Bryant, who's here on an early plea, will be admitting to the VOP in 23 CF 1225, which was a felony VOP with an underlying third-degree felony with a 5-year, $5,000 max incarceration and fines, respectively. There will be an adjudication of guilt to a lesser included offense, misdemeanor domestic violence battery in 23 CF 2457, which is a new law case with a third-degree felony domestic battery by strangulation charge. So that's going to be pled down to a first-degree misdemeanor. And Madam Clerk, I have the statutory references for domestic violence battery misdemeanor in the agreement. Maintain withhold adjudication on the remaining felony count, which is in 23 CF 1225. Reinstate and modify to add special condition of batterers intervention program. And no violent contact with Amanda Jillian McWhirter. Complete original terms and conditions. Continue his current probation in 23 CF 1225. Which goes on for quite a while. I think it has a 2026, no, it's a 2025 right now scheduled termination date. 622 in court costs and 23 CF 2457. $100 VOP fee, $250 public defender fees. And I think I stated 11 months, 29 days concurrent probation in 23 CF 2457, although I probably didn't.
No, you did. It's on here.
Okay, thank you.
What's the underlying charge in 23 CF 1225?
Carrying a concealed firearm, Your Honor, third-degree felony.
State, have you discussed this agreement with the victim?
We have, Your Honor, on November 15th.
Okay, and she's in agreement with reducing the original charge in case 23 CF 2457?
Correct.
All right, sir, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. So there's not a score sheet on?
No, Your Honor, there's just not one required because the sole remaining felony is a modification. I do note that based on the state score sheet, he scores 39.6 points. So he's getting perilously close to scoring prison were he to violate.
Yeah, thank you.
But no, I stand corrected because that was based on the assumption of a domestic violence battery by strangulation. So things would be different because that was listed as a primary offense in the draft score sheet. So it's not going to be a good score, but it's not what I just stated. I apologize.
Okay, thank you. Either way, it sounds like, sir, you're getting very close to prison. So in case 23 CF 2457, that's a new law case. The original charge is domestic battery by strangulation, which is a third-degree felony, maximum of 5 years in state prison. And it's my understanding that the state has made an offer to reduce that charge down to misdemeanor domestic violence battery. Is that correct?
Correct, Your Honor.
And you said the victim is in agreement with that?
Yes.
So that would be a first-degree misdemeanor with maximum of up to 1 year in jail. And then there would be an adjudication of guilt on that lesser charge?
Yes, Your Honor.
All right. And then in 23 CF 1225, sir, you're alleged to have violated your probation in that case. Have you had a chance to talk to your lawyer about the new charge in 23 CF 2457, the original charge of domestic battery by strangulation and the lesser charge that you've been offered to plead to of domestic violence battery?
Yes, sir.
And did you discuss with your attorney the allegations that you violated your probation in 23 CF 1225?
Yes, sir.
Do you understand that you have a right to have a trial in the new case and make the state prove the allegations against you and that you're giving up that right?
Yes.
Do you understand you have a right to have a contested hearing regarding the allegations you violated your probation in 23 CF 1225 and you're giving up that right?
Yes, sir.
Did you read the plea agreement?
Yes, ma'am.
Is this your signature on page 4?
Yes, ma'am.
Do you understand what it says?
I do.
The terms that were announced by your attorney, do you agree with those terms?
I do.
Has anyone promised you anything other than what your attorney announced, which is reflected on the agreement,
No,
to get
Your
you to plea?
No, Your Honor.
Has anybody threatened you or told you that you have to enter a plea?
No, Your Honor.
Are you currently under the influence of any drugs, alcohol, medication, or anything that affects your ability to understand what's happening?
No, Your Honor.
Are you suffering from any mental illness that affects your ability to understand what's happening?
No.
Are you happy with your lawyer?
Yeah.
Did he answer all of your questions?
Yes, Your Honor.
In 23 CF 2457, how do you plead to the lesser included offense of domestic violence battery?
Not guilty. Or no contest, I'm sorry.
Okay, let me ask that again.
Yes, ma'am.
In case 23 CF 2457, you were originally charged with domestic battery by strangulation, third-degree felony. According to the agreement that was announced by your lawyer and the state is offering for you to plead to a lesser included offense of misdemeanor domestic violence battery. How do you plead to the lesser included offense of domestic violence battery?
No contest, Your Honor.
I accept your plea. I find it was freely and voluntarily entered. Any DNA?
No, Your Honor.
And I do find a sufficient factual basis based on the documents in the court file. Sir, do you understand that if you're not a U.S. citizen, that plea could subject you to deportation? I need you to answer out loud.
Yes, Your Honor.
Thank you. In case 23 CF 1225, it's alleged that you violated your probation. Do you admit to the violation?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily entered. In the new law case, 23 CF 2457, I am adjudicating you guilty of the lesser included offense of domestic violence battery. This is in accordance with the agreement between yourself and the state. And in 23 CF 1225, the state has generously offered to maintain your withhold adjudication and to reinstate and modify your probation to add a special condition that you successfully complete Batterer's intervention program. When is he supposed to enroll?
I don't think there's a specific time frame under the agreement, Your Honor. I do think that it is a very demanding program, and it's certainly in his best interest to get it enrolled, but there was not like a 30-day requirement for enrollment. So,
I'm imposing such a requirement.
okay. Your Honor, so the court is, just so he's aware, you have 30 days from today to complete to initiate the Batterer's intervention program, commence.
Yes, you must enroll and start.
Understood.
Within 30 days of today, because that is a lengthy program. It's 29 weeks, if I'm not mistaken.
Okay.
So you need to get started on that right away.
Yes, ma'am.
You do need to enroll and begin within 30 days.
Okay.
And you must successfully complete Batterer's intervention. If you fail to do so, that's going to be a violation of your probation. You're very close to scoring prison if you're not there already. Sir, I encourage you to take this very seriously. Can't speak for the state, but they've been very generous with you on this agreement. I can't say that that would be the case if you were to violate.
Yes, ma'am.
So, other special terms and conditions: no violent contact with Amanda Jillian McWhirter. You must complete your original terms and conditions of probation. The term of probation in this new law case is 11 months, 29 days. You are to continue your concurrent probation in 23 CF 1225, and it is also a term of that probation, this is the modification, that you will complete that Batterer's intervention program and you must enroll within 30 days. And there will be $622 in court costs in 23 CF 2457, $100 violation of probation fee, and a $250 total public defender fee. That would be, I suppose, $150 on the new law case and $100 on the violation of probation.
That's the way it works, Your Honor, is that that includes the $50 application fee and then $100 public defender fees in each case.
Yes.
For a total of $250, including the PD application.
Yes, absolutely. So, have I missed anything or left out anything?
No, Your Honor.
State, did I
No, Your
cover
Honor.
everything?
And he does need to report by 8 a.m. Monday to 13 Kelly Avenue in Fort Walton Beach to initiate the paperwork on the revisions.
Absolutely, you must report at 8 o'clock
8
on
a.m.
Monday, 8 o'clock a.m. Monday morning to probation. And
Does probation need an address, Your Honor?
You did it at the same.
so Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. You should get out today, and I cannot stress upon you enough how seriously you need to take these terms and conditions of your probation. Please don't delay getting started on batterer's intervention. You could violate if you just don't start within 30 days, and you would possibly be facing.
And may I say one other thing on the record, just for his benefit, is that Bridgeway might offer sliding scale in a way that's financially accessible. There are other providers, but just wanted you to particularly be aware of checking out Bridgeway if finances are become an issue.
I'm not sure, I can't speak for Bridgeway, but I think the cost of those weekly sessions is part of the accountability of the program. I can't vouch for them having a sliding scale. Check with them.
Either way, I'm 1,000% committed to getting this
Good.
resolution resolved.
Good luck to you, sir.
Thank you, ma'am.
Thank you.
Good luck. Thank you, sir.
Thank you for accelerating.
Always.
All right, what's next?
Who's ever in the queue, Your Honor, I'm just not sure.
I think it's Davis over there.
Doubleday?
No, I think Davis.
Preston.
Preston Davis?
Yeah, yes, is that Preston?
There's Preston Davis.
Okay, whoever's ready. Go to Steve Medina with Preston Davis, docket 36, 23 CF 199. This is a violation of probation. For purposes of today, we're going to enter a denial. This ties into a failure to appear in misdemeanor court that is contested. I've advised him that we may have to have a VOP evidentiary hearing, but it's possible that the misdemeanor FTA will be eliminated, which might drastically affect the need to go forward with this. He had, not too long ago, had reinstated, there was a positive UA, so he thought he was doing everything right, but an FTA came up, so we're just going to deny the VOP. Excuse me. We're going to deny the VOP and put it off for 12/14, Your Honor. I have drafted a global proposal, but we couldn't pull it off today. The parties are not willing. He's willing to agree, but the state's not willing to at this time.
All right.
Sorry for the long-winded explanation.
So you're already appointed, is that right?
Yes, Your Honor.
Okay, great. All right, sir, so your attorney has entered a denial to the allegations on your behalf, and your court date is December 14th. Is that right?
Yes, Your Honor.
December 14th at 9 o'clock. Good luck to you, sir.
And I don't know if Madam Clerk can advise him on the misdemeanor court date. I think it might be December 4th, but it's possible that he'll do a resolution there that will allow us to possibly avoid the necessity of December 14th, but that remains to be seen.
Okay, it's set for December 4th with Judge Schlechter.
Yes, ma'am. So hopefully he can get that resolved, and hopefully that'll help him over here. Thank you.
Stay in touch with your attorneys, okay, as best you can.
Yes, ma'am.
Thank you.
Thank you.
Good luck to you.
This way, sir.
No promises, but I'm trying. It's possible.
Yes, yeah.
Thank you. Thank you.
That's sir. Not here.
Huh?
Not here.
Okay. I'll leave.
I got you.
Looks like there are 2 cases left.
Dave here, Doubleday.
Your Honor, may I have a moment with Mr. Doubleday? Sure.
Do you have my score sheet?
May I, Your Honor, I'm gonna give him, with the bailiff's approval, I'm gonna give him just plain paper of his score sheet. There's no staple.
I know how to calculate mine, what I score
Have
out
court
to.
security look at it, make sure.
I just know how many points I have, I can do the math and figure that out. Give me something to look at, besides some red balls.
Your Honor, so Steve Medina with docket number 38 with Edgar Doubleday, 21 CF 2592. At this time, in that case, he would be entering a denial, and we would like to remain on the December 14th. It's a felony plea day and 23 CF 2448.
All right, so you want this case to track with the new law?
Yes, Your Honor.
All right. So, and you're already appointed, correct?
Yes, Your Honor.
Okay. So, Mr. Doubleday, your attorney has entered a denial on your behalf to the allegations that you violated your probation. We're going to set this case, 21 CF 2592, to track with your new law case, which is scheduled for December the 14th.
Yes, ma'am.
All right, great. All right.
They've rounded that up to 42 months.
Thank you.
That's my,
Assuming the score is correct.
Yes. Yes, sir.
thank you.
Thank you, Your Honor.
Good luck to you, sir.
Thank you.
I show one more case, or actually two cases, but one person on the docket.
Yes, probably, Your Honor. I think that's right.
All right.
You said you have another?
Are there any individuals left? We're done. The only person I'm, at this time, standing here aware of was Teresa Louise Davis,
That's what I have.
docket 37, 20 CF 1192, and 20 CF 2048. My understanding is she's in Santa Rosa County Jail. Her next court date is like early January. I think we probably would be using judicial economy if we put her on a January VOP docket rather than December 14th, but it really doesn't make a big difference. But I can't really do anything until she gets here.
So what does the state want to do regarding scheduling?
Yes, Your Honor, if we can put her in January, if we have the January dates available to us. If we don't, then we could just leave her on December 14th, and we'll discuss it with Judge Ketchel on the 14th.
I'm inclined to put on the 14th, just in case. She may resolve her
Sure, you never
Santa
know.
Rosa case as the holidays
Yes.
are coming, and might resolve itself. And of course, ahead of time, if it doesn't look like that's going to happen, y'all can reach out to Judge Ketchel and go ahead and
Yes, ma'am.
move it.
Yes, Your
That
Honor.
way she's on the docket.
Yes, ma'am.
Yes, Your Honor.
Also,
Thank you.
Mr. Medina, we have warrant for her arrest.
Yes, sir. When she gets on our hold from Santa Rosa County, the papers will be served, and,
She probably just turned herself in. Probably the best thing for her to do.
well, if she's on a hold, I don't think she'll ever
Oh,
cross
yes,
the
she's not gonna
street.
get released.
Yeah, I don't think, but you tell me, I don't know how that works.
Yeah, if she's not gonna be released, then it'll be served on when she comes here to court.
Right.
In that case. Or
Yes, sir.
I'm sorry,